Is this Garza?
Yes, Judge.
Mr. Garza, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Looks like he has an open felony warrant. Is that right?
Yes, Your Honor.
Let's see. Garza, there we go. All right, are you ready? You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. So it looks like on 4/8, he picks up a weed, and now he gets charged about a week later with an aggravated robbery with a deadly weapon. All right, go for it.
On April 8th, 2026, in Harris County, Texas, officer conducted a traffic stop on a vehicle stopped beyond a clearly marked stop line at an intersection. Officer noticed a strong odor of marijuana, and defendant stated there was marijuana in the vehicle. A probable cause search of the vehicle was conducted, and officer located a plastic bag containing marijuana.
So how far was he across the white line? How did stop? Don't say anything. How far is he across the white line? I mean, is it against the law? Just, it's very conclusory.
The defense states, Your Honor, the defendant's vehicle was stopped beyond a clearly marked white line of the northbound lanes.
Yeah, all right. I'm going to find no probable cause. All right. I have to take you into custody, man. You've got an open felony warrant. I can't let you go. I'm going to find no probable cause in your case, but get the warrant. So that's, I don't know. It's, you're going to hit felony court and then they'll make that decision. That's not mine to make. Please.
All right, Judge, top of 5, Culbertson. Come on up.
All right, good morning, ma'am. Ma'am, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. Anything aggravating that we need to know about with this case?
Taking a look at it, Your Honor.
Yeah. I just, we need to kind of stop you. And you're.
Officer noticed the strong odor of marijuana from the vehicle. And also located a plastic bag of marijuana under the rear passenger.
She's the driver? Passenger?
Next to where the driver's leg would be. Your Honor, the defendant was the defendant was a driver of the vehicle.
She have a license to drive?
I'm running her license right now, Your Honor.
Ma'am, as a condition of your bond, you're not to drive a vehicle unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, then do not drive. Do you have the ability to drive? I mean, to hire a lawyer? Do you have the ability to hire a lawyer? No, that's not my question. Do you have the ability to hire a lawyer? Are you working at this time? How do you support yourself? How old are you, ma'am? Okay, it's when is the last time you've had a full-time job? It's time to start working again. You're 35. At some point, Daddy's not going to be here anymore, and you need to be able to rely on yourself. Get a job. I'm going to bring you back in 2 weeks to see what you have done to get a job. If you've done nothing, it's not going to go well between us. Do you understand? I will have you fill out an application today, but really, it's time, ma'am. All right, come on. What is your last name, sir? Edward.
Top of 6, Judge.
Mr. Edwards, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. Shh. Do you have the ability to hire a lawyer, sir? You were facing 6 months in jail and or a $2,000 fine. I would say so. It's probably pretty important. Are you working at this time? Okay. And what kind of income do you have a month? Okay, we're going to give you time to hire a lawyer. I'm going to have you go to Victoria Sign and Reset. I'm not putting any conditions on your bond. Just be careful. Do not pick up any new cases. Do you understand? Okay, come on. He can, no conditions, THA, go.
Okay. All right, Judge, bottom of 18, Tolliver. Tolliver.
Ms. Tolliver, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. Do you have a lawyer today, ma'am? Okay, I'm gonna have you take a seat. Do not leave. Your case is 217 days old. If you ever take off on me again, I will add a couple zeros by the end of this. There are no more PR bonds for you. Do you understand? We will wait for your lawyer to get here. As a condition of your bond, you're ordered not to have any contact with the complaining witness in this case and not to be in possession of any weapons. We will renew the protective order that was issued in this case prior to. Do you understand? Do not leave until you sign all these conditions. Otherwise, I will issue a warrant for your arrest. Just please take a seat for me. Do not leave. You never sign a reset. Okay, Carlos.
Good one, Your Honor. We have two we're going to approach on the easy one is Malaysia Castillo Ramirez.
Okay.
185 days old with the case we're working on.
Tolliver.
PCI, and it was, we have to go to the deputy chief apparently to the problem.
Have you filed it yet?
I thought we had, apparently not. I
Okay.
don't think so. When we got-
I'll give you 2 weeks. That's it. After that, if you don't have it done, I'm rolling it day for day.
Yes, sir. Thank you, Judge.
Yeah, okay. And the last one
Yeah,
is,
the other one is Mendez. I was out of
let me bring up Mendez. Yeah. So tell me something that you would like reasonable, considering all the cases that I'm not going, reasonable in light of how many cases he has.
Yes.
I certainly willing to give you a bond reduction, but I'm not going to anything that would be just,
Yes.
what do you think?
I think his family can make a total of 10 to 15,000. So I was going to ask if it could be divided up to add to an amount about that much. Each one, I guess, would be between 2,500 and.
I think that's, I'll do 5,000 each, 5,005, but I'm not going, I think it would be just mend it, right?
But thank you for considering.
Yeah, absolutely.
We talked about it this morning.
But so I'll lower to 5,004,
Yes, sir.
okay, each of them. He will have strict conditions, like he's not a 7 to 7 curfew, no driving, no drugs, no alcohol, weekly testing, and then we'll see how he behaves himself.
Yes, sir.
He'll get a scram on his other ankle and then, how's jail? Good. You're not supposed to. But we have to ensure, and we want our community safe. You now have 4 open cases. At great behest, now, I'm going to lower your bond one final time. It will not happen again. If you violate any conditions, and I don't care how minute it is, including testing positive for marijuana, into jail, back you go, and the bonds will hit what they were before. You now know that your family's not willing to pony up a lot of money for you. Do you understand? So if I have to put you in jail again, it's where you will probably end up staying. So each reduce to 5,004, please. So the conditions you have now are 7 to 7 curfew, no driving, no alcohol or illegal drugs. You will get a GPS monitor on your ankle. You must charge it daily. Do you understand? What did I just say?
Must try to take.
Right. On your other ankle, you'll get a scram so I know that you're not consuming alcohol, and I'm going to test you weekly. If you break curfew, and I don't care what it is, even to take out the freaking trash, you will go back to jail. Forewarned is fair warned, and it's not going to happen again. You and only you hold the keys to that cell. There are no mistakes. In this life, there are choices, and you either make a good choice or you make a boneheaded one. Okay, Carlos, got it.
Thank you, Judge.
Good luck, man. Okay,
Judge, can I run with?
Yeah.
I'm sorry. Judge, is that Charles? I've got some problems. I'm currently in a murder trial. I do think the murder trial hopefully will be over by then.
Oh.
But I also have, a federal trial that starts at 2:30.
Mr. Bresson, if you want a continuance, I'm okay with it.
Okay,
I will usually grant one,
right,
but that's it.
okay.
I'm not going to continue to,
What,
continue. No.
I don't really, I continue with the he's in custody, so I'm not wanting to continue it.
Oh, okay.
But what I would like to do is to leave him on the docket because he's in custody on April 21st. And I guess I'll just, I'll file a motion. I've already filed a motion. But,
The problem is I don't want them to have to prepare in the event that we're not going to go.
I can't go on Tuesday. I can-
So I'll grant your
I know
motion.
that, but I'd like, he's in custody and I'd like to keep him on there just in case we can work it out.
Oh, well, that's a different
I mean,
question.
not a case I think should be tried, but unfortunately, this is the guy that kind of,
I don't
he didn't
remember.
go through. Okay, anyway,
So should they prepare for trial or no?
not on Tuesday.
Okay, you heard that.
Yeah, I mean.
Okay, we'll keep them on in the event that you want to work it out. If not, then we can give you a new trial date.
Okay.
But I have to give them enough time
Yeah,
to
I already
subpoena
told him I
witnesses.
this
and-
weekend I wouldn't be able to do it. on
Okay.
Tuesday. Okay.
Okay.
All right. All right.
All right,
Thank you.
good luck, bud.
Yeah.
Hi, please.
Just on Mr. Yacht. Is it the clean one? For its speech that. Okay.
All right, good morning, Mr. Yacht.
So we need to.
Sir, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they were offering you 3 days in jail with credit for the 4 days that you've done. This charge will go on your record. Understand that from now on, for any future DWIs, you will be facing a minimum of 90 days in jail. Do you understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, it stays like this forever. Is this what you want to do?
Yes, sir.
How do you plead to this offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. Follow this agreement. I'm going to suspend your license for 180 days. Do not drive until you get a license. And good luck to you, sir. Thank you. Yes, ma'am. Okay, Sam, talk to me. Just the last name of your client.
It's not on today, Judge. It's tomorrow. I'm a pallbearer and a funeral I have to attend to, and it's over 150 days old. So
How old is it?
I don't know the exact days. We
What's
just
your
did
cause number?
It is 2585390. We just did a TRADS on the 13th.
I mean, you're way old, Sam. So,
Yeah. Judge, we just did the TRAS the 13th, so we got to get that back. But we don't have to do a long one by any means. I got to go to this funeral.
Victoria, can you confirm that he did the TRS? Can I give you cause number? It is 258-5390.
Yes, that is completed.
Okay, I'll give you a week, Sam.
Okay. Thank
And
you, Judge.
no more waived appearances.
Yep. Thank you.
Okay, man.
Angel Taylor had bond violation. She missed a drug test. It missed it this morning. It was negative.
But it continues to happen. It's over and over and over and over.
This is
Is this Audrina Taylor that's picked up the DWI with the,
the first time she's missed the test. Judge, the reason she missed the test is because the phone was off.
Oh, Angel, okay, I'm thinking of the other one.
No, no.
Okay.
She. Yeah,
All right. First BVR?
Yes.
Okay, just admonish her accordingly, please.
Did, Judge.
Okay,
Thank
all right.
you.
Rise for the jury.
All right, be seated. Ladies and gentlemen of the jury, thank you for coming back and not running away. We will try to be as efficient as possible. We'll start with openings and then we'll start with witness testimony after that. Okay? Ready?
Yes, Your Honor.
Okay.
Good morning, everyone. Drinking is offensive. Driving is offensive. Driving while intoxicated is a crime. Today you will hear a case about choices. Specifically, the choice of the defendant to drink and then get behind the wheel, putting the lives of everybody on the road with them at risk. Today you will hear about how on July 25th, 2025, Officer Escobar observed the defendant in his vehicle. Barely stayed within his lane while other vehicles were around us, putting their lives at risk. And we'll hear from Officer Escobar, as well as another officer, Officer Aurora, about what they observed that day, what their interactions with the defendant were like. You will hear from them what signs of intoxication they saw on the defendant. Signs that caused concern for his ability to safely operate this vehicle. You will hear how the defendant refused to perform the standard field sobriety test and how combative he was with the officers. You will hear from the officers what conclusion they reached. The conclusion that the defendant was intoxicated and that he was unfit to be operating the vehicle. You will hear testimony from other witnesses as well that will illustrate the series of poor choices the defendant made that day. The decision to drink, the decision to drive, the decision to get behind the wheel. A series of poor decisions that put our community in danger. After you hear all the testimony today and all the evidence has been presented to you, we're going to ask that you return with the verdict of guilty for driving while intoxicated, because that is exactly what the evidence is going to show you. We ask today, when the witnesses take the stand, that you listen to what they say, what they observe, what they analyze. We ask that you analyze all the evidence you are shown. You analyze the decisions the defendant made that day. We ask at the end of the day that you find the defendant guilty of driving while intoxicated, because that is the exact decision he made. Thank you.
Okay, thank you.
Good morning, guys. Sorry about that. My name is Kiana Sykes, and I'm one of the attorneys who have the pleasure of representing Alejandro Gonzalez today. You met me yesterday, but you didn't get to hear from me, so hello. Thank you for being here. I'm here to tell you about a story of the piece that didn't fit, okay? Yesterday, Sean talked to you guys about this case like it was a puzzle, right? He told you correctly that they, the state, are under no obligation to present every single piece of that puzzle to you for you to get the picture, right? But what he didn't tell you is that what pieces they do provide to you need to fit. They need to make sense. They need to be a part of the puzzle, right? If it feels forced, if it doesn't feel right, then the piece shouldn't be considered. And you have to believe every piece beyond a reasonable doubt, okay? Now, spoiler alert, in this case, I anticipate you'll learn that the blood test is the piece that doesn't fit here. It's the piece that doesn't measure up with reality. And the reason is because over the course of this trial, I anticipate you'll learn that you will not see any slurred speech from Alejandro Gonzalez. There will not be any severe reckless driving characteristic of intoxication. I anticipate you won't see any failure to maintain balance. You also won't see any impairment tests done to measure whether or not Alejandro was intoxicated. You'll also learn that the DWI investigation didn't take place until nearly an hour after the officer made contact with Alejandro. It was never done on the road. Let's just start where it begins, to stop. I anticipate you'll hear from Officer Escobar, who will tell you that our client is driving all over the road, he's swerving all over the roadway in between lanes. However, I anticipate you'll also have an opportunity to review the video yourself. And I anticipate that you will see that there was no significant lane departure, that there was no weaving across the roadway, there was no crash or no near collisions. I anticipate you'll also learn that Officer Escobar, upon pulling him over, will take this minor lane infraction and ask him to immediately get out of the vehicle and subsequently arrest him and went on. I anticipate you'll learn that Alejandro will ask Officer Escobar why he's being arrested, and that the only response he will get from Officer Escobar is that it is because he failed to maintain a single lane. I don't anticipate you will hear on any part of the body cam that Officer Escobar had a suspicion of DWI when he arrested Alejandro. I also anticipate that you'll hear Officer Escobar state that Alejandro was being belligerent or combative. However, just like with the dash cam, I believe you will have an opportunity to see the interaction with Alejandro and see that the evidence supports him being confused and at most frustrated at not knowing why he was being arrested and detained. And again, this is the important part, that when he was arrested and taken to the station, you will learn that the DWI investigation didn't happen until that point, an hour later, after he was on the road. I anticipate that the state is going to rely on the following for intoxication: the alleged swerving, which we've already talked about, and you'll have an opportunity to judge that for yourself. I anticipate that you will hear that he had red, glassy eyes. However, I'm also going to say you will not hear from any witness that anyone tried to narrow down why he had those glassy eyes. They didn't ask him, did he have allergies? Didn't ask him if his eyes were irritated, did he have contacts? Just he had glassy eyes, so he must be intoxicated. And that's what the state is going to want you to do, make assumptions. I anticipate you'll also hear that there was a slight odor of alcohol on Alejandro. Not strong, not overwhelming, just slight. And I anticipate that'll be a problem for you when you learn what the blood test result is, because that slight odor is inconsistent with that result. And finally, I anticipate you'll hear that he was swaying. However, just like with the dash cam, you will have the opportunity to see that yourself and judge for yourself. This case is about what the blood test means, what it should show versus what you actually see. And there's a disconnect. So the state's case is going to come down to a number that's generated from a machine. And that number is going to rely on processes for collection, handling, and testing of that blood sample. And you're going to hear about problems within that process. And when the number depends on it, the process matters. And the most important thing I want to tell you is that we don't have to tell you what went wrong. We don't have to tell you why that blood test sample doesn't match up with reality. We don't have to tell you what step in the process the state messed up. The fact that it's wrong, the fact that it doesn't fit is enough. That's reasonable doubt. And when you look at the evidence, you're considering the blood test result or any other piece, you only can consider it if you believe it beyond a reasonable doubt. If not, it doesn't belong. And at the end of this trial, I anticipate that once you look at the evidence and take a step back, you won't feel like these pieces align, that they do not pass muster. And if that's how you feel at the end, then you must find Alejandro Gonzalez not guilty. Thank you.
Okay, thank you. State, are you ready to call your first witness?
Yes, sir.
Okay, you want to go ahead and do that? If you don't mind grabbing this.
Officer.
All right, sir, if you'd coming up and please raise your right hand.
Right here?
Sure, it's good enough. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Okay, if you come take a seat. Officer Escobar, if you don't mind testifying loudly, clearly, if you hear the word objection, just stop, wait till we address it, and at that point you may continue, okay?
Yes, sir.
Okay, please.
Good morning, Officer.
Morning.
Can you please introduce yourself?
My name is Officer Oscar Escobar. I'm 32 years old.
I'm a 4-year Air Force veteran. Was 4 years as security forces, which is a military policeman. I enlisted in 2013, I got out in 2017, and in 2019, I got hired by the Pasadena Police Department. I'm still currently employed, I've been there for 7 years. I'm a night shift officer. I'm a full-time FTO, SRT, and I've been on nights my entire career.
Thank you. And to break down some of that, what is an SRT?
SRT is just special response team with just crowd control, large groups, gatherings, and events.
Okay. So just to be clear, you're our certified peace officer in the state of Texas.
Correct, yes, sir. After I got hired in January of 2019, and then in August of 2019, I graduated BPOC, which is the Basic Peace Officers Course, which is the police academy, and then I became licensed and certified. I currently hold my advanced license through TCO.
Thank you.
The commission alone.
And so where are you currently assigned?
I'm currently assigned to night shift control.
And what police department?
Pasadena Police Department in Harris County.
Pasadena. So what are your current assignment, the duties on your assignment?
I'm just night shift patrol, so I respond to calls for service, any 911 call, or drive around and be proactive and look for other offenses occurring.
Okay. What does a typical day look like for you?
Check in service, get gas. Sometimes I wash my car, and then pretty much I eat my lunch every day at 2. But on patrol, you kind of just drive around, look for suspicious activities, burglaries. There are some robberies that happen at night, but burglaries, a lot of stolen cars at night, and just drive around and look for crime. And if anyone calls 911, my main job is to go show up and take those reports, or make those arrests or what have you.
Thank you. And so before you became an officer, let's talk a little bit about your training that you had to go through. What police academy did you go to?
Well, technically, I believe it was a 343rd. It was a federal law enforcement training through the Lackland Air Force Base. I think that was 559 hours. I had the certificate at home. And then the BPOC at Pasadena, which is like, I forget how many hours, but it's like 7 months long.
Okay. And for that training, was that field or just classroom?
Okay, so that's just classroom before you're licensed. So once you become licensed and graduate the police academy, you it's like 4 months or 3.5 months of field training. They didn't do that in the military, but on the civilian side, that you do have to do FTO, field training, and there's phase 1, phase 2, phase 3, and then there's ghost phase, and then there's 2 ghost phase. And every phase you learn a little bit more. Ghost phase, you're by yourself. You're not by yourself, but you're supposed to do everything by yourself. And they're just observing you.
Did you receive any kind of training for the enforcement of traffic laws when you're on patrol?
Yeah, you go over everything, both criminal, transportation, penal code.
Okay. And what kind of training did you receive pertaining to DWIs?
In the police academy, they teach you SFSTs, how to work on different signs to look for, what signs of intoxications are. Get certified. At Pasadena, we have a DWI unit, so we have our own officers. We can call on our scene to work the DWI for us.
Okay. And let's break that down for the acronyms. SFSTs, what are those?
Standardized field sobriety tests.
Okay. And those are pretty typical in DWI investigations?
Correct.
Okay. Now I want to talk a little bit about how those investigations are conducted. When you come across a vehicle, can you walk us through what kind of behaviors or driving patterns you're looking at?
Okay, so the main one would be, fail to maintain single lane, you're swerving. Some people fall asleep at the wheel when the light's green and they're still stopped at the green light. Happens in a lot of drive-throughs for the restaurants too. Pretty much anything that would you find PC or find, and then you stop the car. Sometimes they're called in by other passerby. Well, hey, this car's swerving. I typically always like to still find a PC. I don't like to just rely on the third-party driver because I have and sometimes pull somebody over that somebody else thinks is intoxicated and it turns out that they're not, so we can release them. So I always try to find my own PC. And then, yeah, you pull them over, contact the driver, look for signs of intoxication in the car, and then, or on the person. And yeah, if you think they're intoxicated, you call the DWI unit. That's the standard way we do things at Pasadena. That DWI officer will come conduct his investigation and we'll go from there.
Right. Now, taking a step by step here, when you're looking at someone that's driving, and you're seeing something like swaying or swerving, what does that typically indicate to you, or why is that a flag for a possible DWI?
For swerving? Well, just because when you're intoxicated, you know, it's my assumption. I've never driven drunk, so I don't know, but it would be my assumption that you swerve. You can't walk straight and stuff, so.
Okay, so when you're seeing them drive and they're swerving between lanes, what about that is making you think it's a possible DWI?
Well, normally cars don't swerve. You know, I do a lot of traffic enforcement and they don't usually sway back and forth between the lanes.
Okay, and so then after you pull them over and you make contact with the driver, what happens then?
I contact them, I introduce myself, try to talk to them. This is typically, most of the time, right? It doesn't always happen, but depending on the circumstance, I'll ask them where they're coming from, where they're headed, and then I'll conduct my stop. Go back to the car, run for warrants or whatever, and then I don't usually write tickets.
Okay. Now, when you're speaking with someone who's a driver, what are some signs of intoxication that you're trying to look for here?
Slurred speech, slow delayed speech, there's red watery eyes, there's the smell itself. You know, those are pretty much the main ones right there.
Now, in your experience, does every intoxicated driver have every single one of those signs?
Not every one of them. Sometimes it's just red watery eyes, sometimes it's just the smell.
Then do you need every single sign to be present in order to have someone be potentially be intoxicated?
To potentially be intoxicated, no, but again, I'm not the DWI officer, so if I see signs that make me believe that they are intoxicated, I'm just gonna, what we call CYA, we call the DWI officer to arrive to the scene and let him make that determination. Most of the time, we'll do that on scene.
Okay, and those signs that you're looking for, those are taught to you where?
At the police academy.
Okay. And
I'm sorry.
No.
There are times I will ask people to step out the car and I'll try to do what's called an HGN test form. It's horizontal gaze nystagmus. Nystagmus is the involuntary jerking of your eyes. You move it left or right. We've probably all seen it on TV or seen it out on the road. And nystagmus is a sign of intoxication itself.
Okay. Now, we'll get into all that kind of stuff in a minute, but I want to talk about the investigation that you conducted for this case. Now that we know about your training and your experience, let's focus about how you got involved here. Were you working on July 25th, 2025?
I believe so, yes.
Okay. And what shift were you working?
Night shift patrol.
Okay. Where were you patrolling?
I believe on this specific case, it was the 3200 block of Spencer.
Okay. And is that in Harris County, Texas?
It's in Pasadena, Harris County.
Is that a public place?
It's a public 7-lane roadway.
Okay. And were you driving your patrol vehicle?
Yes.
Do you typically have a dash camera on your vehicle?
Dash cam and body cam, yes.
Okay. And to your knowledge, was the dash camera working that night?
Yes.
Your Honor, may I approach the witness?
Yes.
Officer at the bar, I'm handing you what has been marked as State's Exhibit 1. Do you recognize it?
Yes, I do.
What is it?
It is a DVD containing the footage of my dash cam.
Okay. Have you had an opportunity to review that before your testimony today?
Yes, I have.
How do you know it's yours?
I watched it and it's you see me get out of the car and approach the defendant
And how do you know that that disc itself is?
so my signature, I'm sorry.
Okay. And is it a fair and accurate depiction of your dash cam from that night?
Yes, it is.
Has it been altered in any way, sir?
No.
At this time, State offers State's Exhibit 1.
Sure. If you don't mind tendering it, please.
No objections.
Okay, it'll be admitted. So states one is it's Officer Escobar dash cam.
Yes, sir. Now, Officer Escobar, give me a second while I'm trying to have some technical difficulties. Let's see if this goes smoothly. While that's loading, were you also wearing a body cam that night?
Yes, I was.
Judge, may I first look again? Officer Escobar. And you have to mark State's Exhibit 2. You recognize it? And what is it?
This one's my body worn camera footage.
And have you had an opportunity to review it?
Yes, I have.
Okay. How do you know, sir?
My signature initial in the back.
Is it a fair and accurate depiction of your body camera?
Yes, it's.
Has been altered to your knowledge in any way?
No.
At this time, State offers State's Exhibit 2 from this.
No objections.
Okay, it'll be admitted.
So Officer Escobar, while you're on duty that night, did you come into contact with someone by the name of Alejandro Gonzalez?
Yes, I did.
And do you see him in the courtroom today?
Yes, I do.
Would you mind identifying him by article of clothing?
The red and black plaid shirt, button-up shirt.
Thank you. Your Honor, at this time, the record reflect the witnesses identified the defendant.
It will?
That may have published State's.
Yes, of course.
For the record, this is State's Exhibit 1, the dash camera starting from 0. So officer, let's talk about how you first met the defendant in this case. When did you first notice the defendant's vehicle?
I would assume that it was because,
Judge, I would object to the witness assuming if he doesn't have knowledge, speculation.
Right. Sustain, testify to what you know, please.
okay, there was a Chevy truck driving and I just happened to get behind it. I like to go behind Chevy and GMC trucks because they're highly common or they're commonly stolen vehicles.
Now, what did you observe about the vehicle that night?
I got behind this vehicle and the vehicle started failing to make single lane and started going between the left lane and the center turning lane.
So what did you do next after you saw that?
I followed it and tried to make sure that it wasn't just a one-time swerve into the next lane. And so I followed it to observe it swerve a few more times.
Okay. Right, sound good.
I probably ran the plate in between there too. I probably ran the license plate to check if it was not stolen.
Okay. Now, I'm going to play a little bit of this dash cam for you here, and we're going to talk about it. For the record, we're playing from 0. Okay, just pausing at 8. Officer, where on the screen are we looking to see the defendant's vehicle?
He should be a few feet. I don't know exactly how many feet, but he's that car I'm driving right behind in the left lane.
Is it this one here?
That one right there.
Okay. Resuming from 8. Okay, so stopping at 23, officer, what are we seeing so far?
It's kind of far from here to TV itself, but he is failing to maintain single lane. Oh, okay, there's one right here to the right. And he's hitting the right lane into the middle lane of the westbound lanes of the whatever 100 block of Spencer that is. That might be Lafferty or Harvard.
And resuming. Then at that point, you're stopping at 28. Have you seen anything else?
Yes, now he's hitting the lanes to the left of the center turning lane on the.
Okay. And at this point, are there any other cars on the road that night?
Yes, so there were some cars approaching us going eastbound, and there was, from what I see on the video, there's 2 cars going westbound alongside us.
Okay. And is that something that you look for when someone's swerving on patrol?
Now I do, yeah, since most recently, yes, I do.
And why is that?
Because nowadays for fail to maintain single lane, they're kind of stricter on, it has to actually endanger other drivers. And so if they're just failing to maintain a single lane and there's no other motorists on the road, then I'm going to look for stronger PC to conduct a stop.
As far as what we see on the camera today, were there other cars on the road that night?
There were other cars on the road, and he's actually going into the center turning lane.
Okay. And so resuming from 28. Okay, so now you have your lights and sirens on. What's happening now?
Well, the driver continues to drive, and he, I wouldn't say he's evading, because evading is interactive with trying to get away. Eluding, maybe, he's just not stopping after the lights. There's plenty of safe spots to, stop the vehicle. Even in the center turning lane would have been acceptable, but he just doesn't stop and he keeps driving.
Okay. Now I'm gonna back up, there's a little skip there in the video, but we're gonna go back to 27, click there. Okay. Stopping at 51. Now after you turn your lights and you start the traffic stop, does the defendant pull over right away?
He does not. And typically, that's when I start to chirp my siren. Sometimes drivers can't see you or they have.
Objection to narrative,
Your Honor, he's just answering the question.
and he's already.
Well, what's with regard to this case, not other, please?
Yes, sir.
Right.
So off that part, with regard to this stop right now, how long did he continue driving to turn your lights on?
Approximately 0.6 miles.
Okay. And was there anything standing out to you about how he's driving after you turn your lights on?
Yeah, he continues to bounce left and right in his lane.
Okay. And was there any other place for the defendant to pull over after you turned your lights on?
There's plenty of space. I mean, well, yes, there's other cars, there's not heavy traffic, still able to pull over to the right. I mean, there's a driveway right there that we're looking at on camera.
Right. Okay. Now, resuming from 50 here. Stopping at 112. Officer, how many times have you pulled someone over on a job?
I work traffic enforcement as overtime. Typically, it's 4/5 a month, and it's 10 traffic stops per shift.
Okay.
So, I mean, there's at least 40 right there per month.
Okay. When you pull someone over, where do they usually pull over?
By law, you're supposed to pull over to the right. That doesn't always happen, but typically they don't drive 0.6 miles and pass 2-3 lights.
Okay.
Typically, they stop almost immediately and pull over to the right. They're
No.
in the center turning lane.
Okay. Now I'm going to resume from 112 here and see the rest of the stop. Okay, stopping at 155. At this point, we pulled the vehicle over. When did you end up making personal contact with the defendant after this?
I get out of my car and a few seconds after this, I go and I approach the car.
Okay, and who's driving that car?
The defendant?
Okay. Were there any passengers in the vehicle?
No.
And how would you describe the manner that the defendant pulled over that night?
As far as his demeanor or the vehicle?
Let's see the vehicle. How would you describe how the vehicle pulled over?
I would say it's not usual, it's unusual.
Now, when you approached the defendant, did you advise him the reason for the stop?
I can't recall right now.
Okay.
I know he asked, and I eventually, after a few attempts, I did.
Objection, judge not responsive after I don't recall.
I can rephrase the question now.
Right, overrule.
When you approached the defendant, what did you say to him?
I think I asked him to get out the car.
And why is that?
Because it was very unusual for a stop to keep driving. You know, he could be, well, yes, I saw him swerving before. He still could be reaching in his vehicle. You know, it's pretty dark at night. He doesn't take tinted windows to not be able to see inside a car at night. So he could be reaching around for a weapon or what have you. So
Was there anything about the truck itself that gave you concern to ask him to step out?
Well, it's lifted, and so if someone rolls down the window, you can't see inside.
Okay. When you first interacted with the defendant, how would you describe his demeanor that night?
Belligerent.
And why is that?
Yeah, he became argumentative almost instantaneously.
Okay.
As to
And
what the PC was and why I stopped him.
what did you notice about the defendant when you spoke with him?
He had the smell of alcoholic beverage from his breath in person.
Okay. Was there anything else?
Rare water units.
And how did the defendant react when you asked him to step out?
He was asking for probable cause and reasonable suspicion and for the reason to stop.
Did you advise him of why you stopped him?
I think after a few times, I did tell him exactly why. I said, felon maintained single lane and because we didn't stop, because it took him so long to stop.
Now, I'm going to switch over to your body cam at this point. Officers doing him on the wallet, change up CDs. When you're on patrol, how many times are you pulling someone over at night?
Not often, but sometimes.
Okay. And when you do that, sorry.
I said not every time, but it does happen.
Okay. And when you do pull someone over at night, what do you typically ask them to get out of the car?
No, not typically.
Okay. And so what about this defendant's vehicle made you want him to step out of the car right away?
Well, it was lifted.
Okay.
And then for sure, because of how long it took him to stop.
Okay. Let's see. Your Honor, may I publish some state's exhibit?
Yes.
Well, in some state exhibit 2, this is your body camera. We're gonna jump to where we just cut from the dash cam right here. Should be right about 2-minute mark on exhibit 2. Okay, so now that you've spoken to the defendant and you're walking us through what you're observing, what observations did you have at that time?
Oh, sorry, can you ask the question?
Now that you've spoken with the defendant, what observations did you have?
Yeah, the rare water eyes and the smell of alcoholic beverage from this in person.
Playing from minute 2 on exhibit 2.
I'm telling you, Steve. Pennsylvania v. Mims, I'm allowed to get out. The Pennsylvania v. Mims, it's the case law that says I'm allowed to actually get out. Get out. I'm not arresting you, am I? I'm not. I'm asking you to get out. Okay, step out the car. Yes, I do. I'll report that to you. We don't play court in the street. Yeah, we play court. We don't play court in the street. Okay, you can either get out the car or I'm gonna force you to get out the car. Get out of the car or I'm gonna force you to get out the car. Because you took a long time to stop. Why took you so long to stop? Step out the car. Why are you taking? Okay, this is your last chance. You can get out the car or I can force you out the car. Why are you Pennsylvania?
Stopping at 305. And the other times that you have asked people to step out of the car, how often do they comply?
Objection relevance.
Yeah, we're asking you about the defendant stepping out of the car here based on his training experience. You can answer what happens on a normal DWI investigation.
Sustained. Just let's talk about this one.
How many times at this point do you think you've asked the defendant to step out?
I haven't counted, but at least.
Objection speculation.
Would you say it's more or less than 2?
More than 2.
Thank you. Resuming from 305.
Hey, what do you mean? I'm allowed to go ahead. Okay, because you're working all over the street. So you can step out. You were working in the street. It's on body camera. Step out of the car. Step out of the car. Step out of the car. Well, how else are you gonna get out? If I'm moving, right? Step out of the car. Why am I being taken? Step out of the car. Why am I being taken? Because I already told you. Why? You're swerving all over the road. Okay, you can get or I'm gonna force you out the car. Okay, I already told you, you're swerving in between lanes. Get out of the car. Okay. Get out of the car. Don't make me force you out the car. Get out of the car. I'm not retaining you out of the car. Now you are gonna be detained. Because you were swerving all over the road, and you should have went on stop. Fail to maintain single lane. Why you continue? Why you continue? Fail to maintain single lane.
Stopping at 4 minutes and 2 seconds. Based on your training and experience, why is him not stepping out a concern?
Because there could be weapons in the car and he could take off.
Okay. And we heard you cite a case law in there. What was that?
Pennsylvania v. Mims.
And what is that?
It says that officers are allowed to ask motorists to step out of their vehicle for officer safety.
Have you ever done that based on your training experience in other investigations?
I have.
Now, at this point, you're taking him out of the vehicle. What do you do next?
I put him in handcuffs
Why?
because he's already uncompliant.
Okay. And based on the signs that you've already told us about, what was your next step in the investigation?
Well, right now, at this point, I was placing him under arrest for failure to maintain single lane.
Okay. Is that an arrestable offense?
Yes.
So after he steps out and after you have him in handcuffs, what do you do next?
I radio dispatch and have them send a DWI officer because I also observed the red watery eyes and the smell of alcohol.
Okay. Playing from 4 minutes and 2 seconds.
I was told you stay right here. Fail to maintain single lane. Well, can I get a 460?
Now, stopping at 4 to 11, what was that radio?
I said 12, which is our radio numbers are based off seniority. So
Okay.
there's 31, 32, 33. 31 is days, 32 is evenings, 33 is nights. I don't usually say 33 because we're already on night shift, and 12 is who I am. I'm actually I'm on 9 this year. But instead of saying 3312, I just say 12. They know it means me, and then I say, can I get a 460 unit? A 460 unit is a DW officer.
And after you radioed that, what was the response that you received?
They said negative transport.
What does negative transport mean?
There's not one available to come to the scene. Have transport them to the DWI investigation room that we had.
Okay. And based on your time at Pasadena Police Department, is that typical?
It's more or less. It does happen occasionally.
And at this point, why did you call that in?
Because it's just easier for the DWI officer to arrive to the scene to do the DWI investigation on scene.
Okay. Now, resuming from 411.
Go back to my car.
And so that call out to you, what was that saying?
You'd have to go back so I can.
Oh.
That might have been someone else being dispatched to a different call.
Yes, sir. I'll give me 1 second to offer. So after you radioed out, they responded to you.
Correct.
And what was that response to you?
Again, it was just to transport them to we call it room 2.
What's room 2?
Room 2 is where we investigate the DWIs. The DWIs.
What is DV what you would call it?
DWI is it's like if you sound out DWI, it's DWI, so we call it DWI.
Okay. So did you try to have a DWI investigation done on scene?
I did.
Okay. And what did you do instead?
I transported them to the room 2.
Why didn't you conduct one yourself?
Because we have designated DWI officers. It takes several hours to do a DWI investigation. And so to, I guess, maximize the manpower, we have DWI officers. That way I can just give it to him and I can go back out on the street and major call drops.
Okay. And so at this point now you're putting him in the back of your patrol car. Where did you take him?
Room 2.
Okay. And then where is that at?
That's located at the Pasadena jail.
And at this point, what did you believe was the appropriate next step for the investigation?
Well, we have to tow the car.
Okay. So the defendant's going to the station, and he's in your patrol vehicle.
say it again.
The defendant's going to the station, and he's in your patrol vehicle. Was there anything about the defendant's behavior at this point that stood out to you?
Yeah, he was still very belligerent.
Okay, and would that be an indication of anything for your investigation?
I mean, working nights, we deal with a lot of intoxicated people and they're very belligerent, yes.
Now, so I'm going to go back to State's Exhibit 1, your dash cam here. So, was the defendant talkative in the patrol car?
Very.
And after you placed him in the back seat, what did you do next?
Transported into the jail.
Okay. Was there anyone helping you on scene with the truck?
Yeah, so my backup officer arrived, took custody of the truck. So, we can't just leave it there unattended. So until the record driver comes, she stays with the truck.
Okay.
Gives it to the record takes the truck.
Okay. So in place State's Exhibit 1 from minute 5. From 454. Close. And so right away, who is this on camera?
It looks like Officer Formosa.
Okay. And what's she doing?
We have to do an inventory of the vehicle prior to it being towed.
Was she with you on scene when you're getting him out of the car?
I don't believe so. I'm not sure.
What gave you call the turkey? What gave you call the turkey? What gave you call the Yeah, what gave you call the turkey? What gave you call the turkey? Fucking pussy, bitch.
Stop
What gave you
at
call the turkey?
540. Did you go back to help her with the inventory of the car?
I believe so.
And playing at 540. Did you find anything in the car?
I did not.
Then this is you
Yeah,
going
he
back
had
to
no
search.
cause to search me. That's why it's motherfucker. Got no cause to search, nothing. No public cause to search nobody. Yeah, pussy ass fucking testing in a car. That's what y'all like to do. Like a bunch of pussy. Like to do that. Like a bunch of pussies, y'all like to do that. Search people shit. Thank you, y'all fucking right. Fucking pussy ass bitch.
Stopping at 6 minutes and 26 seconds. On the way to the station, did the defendant say anything that made you think he was intoxicated?
I don't recall.
Was there anything standing out to you about how he was speaking?
I don't believe so.
Now, playing from minute 8. Or 7:58, apologies.
Hey, tonight I'm going to go ahead. Yeah, fuck you, boy. You're good. Pussy, you boy. You fuck. I make money too. I make money. You better make sure you fucking BA got everything you need. Fuck. Yeah, you got to shit on it. What? Let's get paid tonight. Y'all still here. Fuck, take me in. Fucking do. Fucking do. Fuck, yeah, you can just talking to you. Fucking yeah.
Stopping at 8:42. Officer, what's a PI?
Public intoxication.
Did that influence your investigation in any way?
Well, no, because you can't PI someone after driving a vehicle. PI is like when someone's a danger to themselves or others and they're intoxicated in a public place, but under this circumstance, he's driving a vehicle, so it'd be a DWI.
Okay. And so the defendant What about the defendant saying public intoxication stood out to you, if anything?
You mean that?
At this point, what were you doing? What was your next step in your investigation?
Just getting them down to room 2 so that Officer Rohr could do the DWI investigation.
Okay. And did Officer Rohr meet you at the station?
He was in room 2, correct.
Officer, based on your training and your experience as an officer with a number of investigations and everything you saw that night, did you reach a conclusion about the defendant?
In what regards?
About the defendant's state that night?
I mean, I was just arresting them for failed to maintain single lane.
Okay. And then your next step was to take him for investigation about what?
For DWI, so that Officer Rohr could be the one to determine if he was intoxicated or not.
Thank you. That's what it's wrong.
Okay. Floor is yours.
Good morning.
Good morning.
Okay, so let's take a couple steps back. You said you're not part of the DWI unit, right?
No, ma'am.
Okay, and the only formal training you've had for DWI would have been in the police academy, right?
Yes, ma'am.
And when did you go to the police academy?
January 14th of 2019 to August 9th of 2019.
Other than that, no other trainings or anything like that?
No other trainings other than what we experienced on the street.
Okay, and with the DWI unit, they receive more trainings, right?
Correct.
Okay, and that's because they need to be in a better position to assess whether or not someone's intoxicated.
Correct.
And I heard you earlier say that sometimes you observe things into CYA, you send it to the DWI task force. Is
Correct.
that accurate?
Correct.
What does CYA mean?
Cover your ass.
So that, would you agree with me that that means that sometimes you would send things to the DWI unit, not knowing or having an opinion whether or not they are intoxicated?
I'm sorry, say it again.
Sure, my apologies. So you would agree with me, that would mean that sometimes you send cases to the DWI unit, not knowing one way or the other whether they're intoxicated.
Correct. And we release them when they're not.
Okay, and when you send them. And you mentioned earlier that it's not illegal to fail to maintain a single lane by itself, right?
Well, according to transportation code, it is, but it needs to be stronger in certain circumstances for it to be considered in a DWI case.
Well, outside of DWI, when we're talking about a traffic violation for failing to maintain a single lane, right?
As written in the transportation code, it's illegal, yes.
Sure, and courts want you to find that something stronger, right? And what is that something stronger?
It could be anything.
Well, earlier you mentioned that it's posing a safety risk to somebody, right?
Correct.
And not a hypothetical risk, right?
An articulable one, yes.
Okay, so one, okay. Yes. And also, just to clarify, when you're saying someone's failing to maintain a single lane, you're looking for them actually departing from their lane, right?
Correct.
Is that a full departure?
I mean, it could be full departure or not staying within the lane.
So how do you determine that?
It just depends on how many times a driver does it.
Well, I'm not talking about how many times, I'm just saying for you to determine that it's even happened one time. What is a departure under the law?
I mean, every situation is under the law, it just says a person maintain a single lane.
Sure, and I just want to help the jury explain what it means to fail to maintain a single lane. And every situation could be different, but in this situation, to you, since you've articulated that, what does it mean to fail to maintain a single lane?
In this case, I articulated it because he did it more than one time on both sides. It wasn't like, I'm reaching for, like I've had cases where I'm reaching for a drink, or I'm looking at my phone and I just wasn't paying attention for a second or two. I got behind his vehicle and I followed it for several seconds before I activated my camera. And I articulated that he was doing it on both sides.
Sure, what was he doing? That's what I'm asking.
Failing to maintain single lane.
Okay, did
He crossed it and he was bumping them.
he completely left the lane?
I believe so. My camera only goes back 30 seconds, but I followed him for several.
Do you recall him completely leaving the lane?
I can't recall that right now, but I
Okay,
believe he
understood.
did.
That's fair. And when you say he's bumping in between lanes, is that illegal?
If his tire is crossing the line, I would say it's failed to maintain the lane.
But you described it as bumping in between his lane.
Well, yeah, bumping, but you're not just touching the exterior lane, you're crossing it, you're going into the next lane over.
Yes, if it's not amazing. For the record, we're in States Exhibit 1, we're going to around 8 seconds. Okay, you could pause. Okay, I want you to stop me when he fully exits his lane, okay?
It looks like he's across the lane right here.
Which lane? We have a left and right
The
lane.
center turn lane.
You would agree with me, there's a light right there, right?
That's on the right side of the vehicle. Center turn lane.
Okay,
on the-
start. Where's it?
Right here, I would say he's bumping, but when you first started the video, I would say he's over the lane there and inside the center turn lane.
Okay, so that was one.
Here he is again.
Are there any cars around him at this time?
There's one, if you go back in the video, you'll see there's actually a car in front
Okay,
of
can we
us.
go back in the video then?
And there was just some cars that crossed us driving the opposite direction as well.
Let's get back there. Okay, we pause. How many cars do you see on the road right now?
I believe there's 2 cars coming towards us and there's 2 cars going with us right here. There's 1 car in the center lane up further ahead, and then there's one in the far right lane.
And you would agree with me that the one that's closest to him is the one that's in the far right lane.
Correct.
And there's at least a whole lane of space in between him and that car, right?
Correct. The Spencer
Okay.
Highway is one of the longest roads in Pasadena.
Okay,
You're just gonna drive by multiple
sure.
cars.
Just for the purposes of this bill. Right.
For the purposes of this, still correct.
Okay. And on the other side, there are cars traveling this way, right?
Correct.
Okay, and is there something separating?
There's no center median.
Is there space separating
There's a center turn lane.
in between him and the other cars, right?
Correct.
Okay,
At the purpose of this still, yes.
sure. So the purposes of this bill is what danger is he posing to any of those cars around him?
In this specific still shot,
Mhm.
in this specific still shot, he's going into the left lane where there's cars approaching.
Is he almost hitting the cars?
Well, there's a center turn lane, but
So
there's no way to know if someone's gonna go into the center turn lane to turn into that McDonald's right there. We happen to pass by. My job is to prevent the endangering of public, so he might not crash now, but he could easily crash on this main 7-lane highway in Spencer.
Did he crash?
He did not crash.
Okay, and so it sounds like there's a hypothetical risk then.
There's a lot of crashes on Spencer Highway.
That's true. And when we talk about when somebody is guilty of failing to maintain a single lane, we're looking for that, the failing to maintain a single lane, so the departure, right? Plus a danger to the cars around, right?
Well, I don't deter you guilt.
Sure, I'm not asking you to.
Well, you just said something about guilt.
No, and if I did, that's a misspeaking. What I'm asking you is what you do determine whether or not you're gonna stop somebody, right?
Correct.
Okay, so you have to have at minimum, basic understanding of the law to do that, right?
Yes, ma'am.
And so we've already agreed that the law says for a failure to maintain a single lane, we need some sort of departure, right?
Well, I haven't read the transportation code, but I haven't read it right now, but if he fails to leave his lane, I would say yes.
Okay, plus, and I don't need you to read the code, we already agreed on this earlier, right? Plus a danger to another car, right? and not a hypothetical danger.
Well, the danger to another car isn't written in transportation code.
But that's what we've established that courts want, right? So it's not just a technical violation.
Well, I mean, it depends on which court, but yes,
Okay, we're agreeing right here, fair?
sure.
Okay. And so we also agreed that it cannot be a hypothetical danger. Right? So not he could have crashed it, and not Spencer Road is a long road and they have many crashes, right?
Can you re-ask the question?
When we agreed about the danger, we agreed that it is not a hypothetical danger, so it can't be, well, he departed and he could have hit somebody, right? It's whether, right? Is that-
Well, if it did hit somebody, that would be a crash, so
Okay, fair. And no crash happened here.
no crash happened here.
Okay, and at all times, for all intents and purposes, there's a lane separating from all cars, right?
I'm sorry, say the last one again.
Sure. And while you're observing him, you're following him, for all intents and purposes, there are lanes that separate his vehicle from other vehicles, right? We talked about this.
On this still shot, yes.
Okay. All right. Okay. Let's switch to, let's switch to Big Exhibit 2, sorry.
Yep.
And when you finally get him pulled over, right, you make contact with him.
Same.
And it's your testimony that he was immediately belligerent, right?
I walked up to the car and I said, step out the car, he became belligerent.
Yes or no, I'm sorry.
Yes,
Okay, what does belligerent mean?
uncompliant, yelling, argumentative.
So immediately when you asked him to get out of the car, he was yelling at you?
Well, I wouldn't say yelling. You asked me the definition of belligerent and I gave
Sure,
it.
and because you called him belligerent immediately. So I'm just trying to get a good idea, and
Well, he became argumentative.
so maybe not belligerent,
And uncompliant.
but not belligerent.
Well, I would say with a combo of the two, I would say belligerent.
And so your definition is that belligerence includes yelling, right?
Well, I mean, it's case by case, but yes.
Okay, and so in this case, was he yelling at you?
I wouldn't say in this case he was yelling at me.
Okay. And what does it mean to be argumentative?
When you argue, I mean, I don't,
I know, that's a weird question, but we need the jury to understand when you're making these assessments of people, how you're coming to those conclusions.
if I say, hey, step out the car and you're saying no, and I'm giving you multiple chances to step out and you just keep arguing with me back and forth, telling me, trying to play court in the street, I would say that's argumentative.
Okay, fair. When you asked me to get out, did he tell you no?
He refused.
Did he tell you no?
He implied no by
Okay, so he
refusing.
never told you no to your request to get out.
Not literally saying the word no.
Okay.
He did
What
not.
did he ask you
He said,
instead?
why did you pull me over? And what's the reasonable suspicion? What's the probable cause?
And before he asked that, you talk about playing court in the streets. What does that mean, playing court in the streets?
That means we're not gonna play court in the street. We're not gonna, I'll tell you why I pulled you over, which eventually I told him, but we're not gonna go back and forth on. If I've already explained to you, I'm not there, like I said, I'm not there to prove guilt in the street.
So and you cited a court case to him, right?
Pennsylvania v. Mims is case law.
So you were playing court in the streets.
Well, he asked me, why do I need to get out? And I said, Pennsylvania v. Mims.
So what was the function of you telling him that case if you didn't want to play court in the
To
streets?
know that it was a lawful order to get out of the vehicle.
Okay. And
Yes, it's up.
do you usually, when you pull someone over, tell them why you're pulling them over?
I sometimes do, most of the time, yes,
And does that help smooth things over with the traffic stop?
it does.
Helping people feel more comfortable
It
with what's
does.
going on?
Yes, it does.
Okay. And you also stated, you also stated that Pennsylvania v. Mims allows you to pull someone out for officer safety, right?
Correct.
What about his vehicle made you feel unsafe at
Well-
that time, or him?
The vehicle, it's hard, like I said earlier, it's hard to look inside. He had already continued driving for
Mhm.
approximately 0.6 miles. And like I said, he could be reaching for something. He could be not looking at the road to, look inside his glove box or center console, or he could be reaching over. And, it's harder to stay straight when you're reaching over.
Sure.
Could be a number of things.
Did you see him doing any of that?
His windows are tinted too, and as I said earlier, it's hard to see already at night.
Sure. But did you see him doing any of that?
No,
Okay, so there's nothing you can articulate here that would have made you fear for your safety as an officer
well,
from his behavior
from the argumentative,
before you pull him over.
from before I pulled him over, it was taking a long time to stop. It's very unusual. It's not normal for that to happen.
Okay, and when you pull someone over, do you think it's normal for people to feel nervous?
I would say, I get nervous when I get pulled over.
And you're an officer, right?
Correct.
And so could that have contributed to why it took him so long to pull over?
He
Him
was-
trying to find a safe spot?
In my opinion, he was more upset than he was nervous.
How would you have known that before you pulled him over? I'm sorry, I know we're
before-
jumping around a lot. Let me, okay. We're back before you met him, right?
Mhm.
You're saying you observed him to take a long time to pull over, right?
Correct.
So all I'm asking is, could his nervousness, could he be nervous, right?
Correct.
And could that have contributed to why it took him so long to pull over?
I don't believe so. Because if the average person gets nervous on a traffic stop and the average person still pulls over immediately, this vehicle did not.
What's the statistic on that?
There is no statistic. I'm just,
So where are you getting that from?
from all the traffic stops I've done, I would say majority, I can't pull a percent because I don't know, but majority of them pull over immediately.
And what's
So-
immediately?
As soon as I turn my lights off, they either slow down, start moving over, put a blinker on to move over, and I'm like, okay, and they're gonna pull over right here.
Did he use blinkers?
Use the blinker to turn left.
Okay. And did you suspect him of trying to evade or elude you?
I would say eluding, as I said earlier. It was not evading, but it was more of an
Do
eluding.
people who elude you usually use blinkers to do so?
Objection.
They do.
Speculation.
Sustain.
Did he speed up when you got behind him and lit him up?
Just, if he sped up, I would say that would be more evading. In this case, like I said, he wasn't evading. He just wasn't stopping. It'd be more of an eluding or just not stopping.
Did you charge him with eluding or just not stopping?
Me, I only charge him when failed to maintain single lane.
Do you have any personal knowledge of him being charged with that at all?
With eluding or
Or-
evading?
Yes.
I don't believe so. No.
Okay. Okay, and so you also indicated, other than the belligerent but not belligerent activity, that you observed red glassy eyes, is that correct?
Correct.
What time was it when you pulled him over? About?
I can't recall.
Okay.
I think the report says 2:00,
And that's fair, I think we can agree on that, and that's in the morning, right?
2 a.m. Yes.
Okay, that's pretty late, right?
Yes.
And could his red eyes have come from him being tired?
Objection. Speculation.
I mean, he did investigate, overrule. You can answer the question.
Red glassy eyes is a sign of intoxication.
Sure, but also part of your job is to distinguish between signs of intoxication and signs that have other explanations. Would you agree with me when I say that?
Well, so from what I know from my experiences, the DWI officer, when he does his investigation, and I'm sure he'll come and testify to that later, he will ask him when the last time you see, and the only reason I know this is because I translate for a lot of DWI investigations, because I'm a Spanish speaker and most of them don't, so.
Okay,
they
and I
ask
would object to his answer as non-responsive. My question is whether or not you would agree with me that you have to distinguish between a DWI sign and something that can be explained by something else.
Yes,
Okay, so everything you observe can't just be, oh, check the box and it's a sign of intoxication. You would agree with me, right?
correct, yes.
Okay, and so red glassy eyes, while it is a sign of intoxication in some cases, it could also be explained by other things. You would agree with me?
Correct.
Okay.
We look for multiple signs, yes.
Sure, and when you notice those signs, it's your job, or it would be pertinent on you to exclude other reasons for those signs, right?
Can you say that again?
Sure, that was kind of funky. When you notice those signs, a good investigator would try to rule out other explanations for the presence of those signs. Would you agree with me?
Correct.
So with red, did you do that in this case?
I didn't charge him with DWI.
Sure, but you referred him to DWI units, so you clearly thought there was enough, right?
I'm not the one to determine if he's intoxicated.
And you're the one who determined that he had to get
I
investigated.
determined that he had been drinking Not that he was intoxicated.
Okay, so how did you determine he had been drinking?
His red watery eyes and the smell of alcoholic breath on his breath insurance.
Do those things by itself mean someone has been drinking?
It's possible.
But does it mean that?
It's possible.
Are there other explanations for both of those things?
Not the smell of alcoholic breath in person.
So someone can't spill alcohol on you? And you smell like alcohol?
I mean, I guess, yeah. Could
Okay, so
happen.
that's another explanation, right?
Yeah.
Okay, and also, is it illegal to have a drink and then drive?
To drink and then drive?
Mhm.
No, you have to be over 0.08.
Okay, sure. So what about Alejandro at that point made you believe that he was intoxicated?
Well, like I said, I didn't charge him with that. I charged him for failure to maintain single lane.
Well,
I'm not there to determine if he's intoxicated. No, that's what the DUI officer is for. That's why I don't charge people with DWI. I have never filed a DWI charge in my career.
so does every person that you stop who admits to having, or who you determine has alcohol in their system, do they get referred to DWI unit?
So typically,
Yeah, yes or no?
I mean, it's case by case. I have pulled people out, I have suspected of drinking and then let them go. It's just case by case for traffic stop.
So with red glassy eyes, you didn't ask him if he was fatigued or tired, right?
He didn't give me the opportunity
And
to.
I'm just asking about what you did. Did you even ask him?
I planned on it.
Did you ask him?
I did not ask him.
Okay. Did you ask him if he wore contacts and maybe that could have contributed to the red glassy eyes, the irritation?
I did not.
Did you ask him if he had allergies?
I did not.
Okay. And you also mentioned that when you happen upon people who you suspect of DWI, you ask them where they're coming from, right?
I asked them to step out the car and I checked their eyes for HGM.
Did you check his eyes for HGN?
He did not give me the opportunity to.
Did you check his eyes for HGN?
I did not.
Okay. And HGN would have at minimum confirmed your suspicion that he had alcohol in his system, right?
Correct.
So when you sent him to Pasadena jail to be investigated for DWI, you didn't even know whether or not he had took alcohol, did you?
That's why I arrested him for failure to maintain single lane.
Killing two birds with one stone, huh?
It's PC.
Okay. Pass the witness, Judge.
Okay, anything further?
Yes, Judge, briefly, right?
Brief.
Yes, sir. So, officer, let's go back to failing to maintain single lane real quick. Is it a traffic violation to drive on the left side of the road?
I'm sorry, repeat the question.
Is it against the traffic code to drive on the left side of the road
On the left side of the road, yes.
across the yellow lines?
Across the yellow line, yes.
Okay. And was the defendant in this case driving over that yellow line?
Yes.
Now, why is driving over that yellow line a concern for you when you see his vehicle?
Well, there's cars approaching.
Is it your job to wait for a crash?
It is not my job to wait for a crash. No, it's not.
When you send cases to the DWI unit, what do you mean when you send them to the DWI unit because you don't know he's intoxicated?
Ask it one more time.
Can you just explain what you meant by referring someone to the DWI unit when you don't know if they're intoxicated?
Correct. Yeah, like I said, I know what signs of intoxication are. It's not my job to determine if they're intoxicated. That's why we have an DWI officer.
And based on your training and experience and the totality of everything you saw, why did you take him to the station for Officer Moore to do the DWI investigation?
Because I believed he had been drinking. And if he's not intoxicated, then we won't charge him with DWI.
And all those questions about contacts and being tired, are those something that you asked or a DWI officer asked?
The DWI officer asked, I will ask if they need translation.
Okay. Thank you, officer. Nothing further, Your Honor.
Nothing from the defense.
Okay. May this witness stand down.
Yes, Judge.
Okay.
Oh, I'm
You're excused. Thank you so much. Yeah, no, we're taking a break. Absolutely. We need to take a break. Ladies and gentlemen of the jury, we're going to take about a 5-10 minute break. We have some housekeeping matters to take care of, and I'm sure that you guys need a little bit of a break as well. So we'll have you step out. Please remember, do not discuss anything about the case while we're in recess. Okay, please. Okay, guys, come on. Yes, sir. Come on. Just the last name of your client. Okay, what's your cause number?
It is 2-2-2.
Okay,
So Martin Malik Davis. It's an assault violation. He came on bond conditions. He's still in high school and the complaining he's still in high school. So he may go to Lamar. The issue is if you have to put your bond conditions that are 200 feet from each other, there's an issue with them trying to withdraw, making him off of the school. He's a senior, he has a scholarship. It's like a month left in school. With the current bond conditions, they're trying to basically expel him from the school because they're saying you can't be in the school according to your bond conditions. So I was wondering if we could sort of amend the bond conditions.
let's reach out to the state to see if they can reach out to her to see what her opinion is, because the last thing I want is him to try to have any kind of contact with her.
Oh, I understand that.
And then more issues, so.
I don't know if you can just say there's no contact.
Yeah, but make sure that she is okay with it. I want to make sure that there have been no issues
Okay.
since then.
Okay.
He's behaved himself essentially, and then we'll go from there.
All right, thank you.
Yeah, of course. Herman, hey, bud.
I'm Ms. Watson, Judge.
Okay,
Yeah, this morning she said that she was testifying before 97, and I don't know.
she was doing what?
Testifying before 97. Yeah, so I got verification that they weren't going to trial tonight. I completed my check-in with them.
They're not going to trial.
Yes. Or that they were not going to need her to testify.
Okay,
And so I told her to go up there and check in with them, and then as soon as we're finished, to go, either report back here to 4-5 or to go to our office for Christie. And so I verified with the jail upstairs that, yes, was told that she needed.
okay. She has until the end of docket.
Yeah, I'll be trying. I just like this one.
Well, let's make sure, but,
Yes,
you
of
know,
course.
right.
She let me show up.
Yeah, of course.
Okay.
All right. Hi.
Judge, I'm here on Dr. Canales. I find the motion to go because of the exact indication about the time. Canales.
Where's the defendant now?
It was set for today, Judge.
Oh, okay, so the person hasn't shown up?
No.
Did you let them know to be here? Got it, okay. Let me see. Okay, I'll wait, obviously until the end of docket. I'll grant it if they're not here, and then I'll revoke the bond, okay?
Thank you.
Got it. Okay, counsel, ready? Come on up. Okay, hey, give me 1 second. Of course. Where's Victoria? Okay, what's the last name?
Farris, Farris.
In jail, right?
Yes, sir.
Yes, Judge.
Hey, we have a lawyer that was trying to do a plea here earlier. Oh,
The woman.
yeah. Oh, there you go. Okay, great. I wanted to make sure that we found. Okay,
You just let me refresh your memory on this.
no, tell me. Yes, sorry. It's been a long morning.
This is one, he has been in for a minute, and he's got back on bail. You were pushing on whether or not to find housing, because it's an AFN, do not have any of that.
So just, you can have a couple days or whatever you want. I'm not going to just let him out for the sake of, for the streets.
Do it, so we can put it on docket.
Yeah, have me take a day, a week, a weekday, whatever you want. Yeah,
We'll do, and also pushing on Florida.
Okay. Yes.
The reason we're approaching is because the UNC is old.
okay, what are we doing with these cases?
We have an offer
Okay,
to dismiss the UNC and plea on the possession. And I've only had a possession since February, so I'd like one more setting to be able to decide what we want to do about it.
okay, I'll give you 3 weeks, but at that, he's got to be here to make a decision. He's got a, does he have a bond violation?
You took a bone violation. He took a UA this morning and he came out
He came what?
negative.
Okay, great. All right, well, you're good. Yeah, okay. Hi, Sebastian. Good morning. B, okay.
Or my EPA already. I broke the Bernadette. We're gonna do a jail, reentry.
Okay, yeah.
Jail instruction.
sure. Okay, just file it, I'll sign it.
Yeah, it should already be in the.
I haven't.
I'll make sure.
Yeah, I'll sign it for you. I've got it.
Let's take a house today.
Who are you here for?
I have Mr. Garcia, and Mr. Vasquez there.
All right, good morning, gentlemen. Good morning, gentlemen. Who is Mr. Garcia? You're Garcia, and so you are Mr. Vasquez.
Yes, sir.
Each of you are charged with criminal offenses. Each of you have worked out agreements to resolve both of these cases. Both of these cases will end up on your record. Both of you will also be facing minimum time in jail for future offenses. Mr. Garcia, you're charged with theft. You are facing up to 6 months in jail and for a $2,000 fine. The agreement that you have worked out is 15 days in jail with credit for the 4 days that you have done. Is this how you understand the agreement?
Yes, sir.
Mr. Vasquez, you were charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They are offering you 30 days in jail with credit for the 4 days that you have done. Is this how you understand the agreement, sir?
Yes.
Both of you are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Is this what each of you want to do?
Yes, sir. Yes, sir.
How do you plead to the offense of theft, Mr. Garcia? Guilty or not guilty?
Guilty.
Mr. Vasquez, yours is quite a bit more serious. What happens if you pick up another DWI?
Immediate jail.
Prison.
Prisión, señor.
You were looking at a minimum of 2 years in prison, a maximum of 10 years in prison if you pick up another DWI. For you, I would never get in the car, even if you've had a sip of alcohol, because you are taking a huge risk. I will find each of you guilty. You will now be facing a minimum of 30 days in jail. Mr. Vasquez, you will now be facing for any other cases other than a DWI, a minimum of 90 days in jail. I am going to suspend your license for 1 year. Do not drive. Good luck to both of you.
Mr. Lyons, over 200 days.
Okay.
CTI, he's done everything, but he mailed in the money order, but he sent me a picture of the money order, so.
Great, but how do we know he mailed it in though? Do you have any proof?
Well, we sent him the money order for copies to, but he mailed it in because it was last week.
When did you mail it in?
Last week.
Do you have?
They don't have it.
Okay, so let's roll it 2 days. I'm not gonna just, it's over 200 days. 2 days, and he's got to be here. Okay. What is the gentleman's last name? Okay. Yeah, I have it here. All right. Good morning, sir. Are you here for Mr. Reyes?
Yes, Your Honor, I'm here.
Oh, it is. Okay. Sir, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. The agreement that you have worked out is 3 days in jail with credit for 2 days that you have done. You need to understand that this, shh. You need to understand that this charge will go on your record. It will be there for the rest of your life. From now on, you will be facing a minimum of 30 days in jail. You understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Is this what you want to do? How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Yeah, well, follow this agreement. I am going to suspend your license for 90 days. Do not drive until you get a license. For you, it's going on your record. I would never get in the car, even if you've had a sip of alcohol. Because if you get pulled over, it very well may not go well for you. Good luck to you, sir. Thank you.
Thank you, Your Honor.
Good to see you. Hey, you ready?
Mr. Riley from yesterday.
Okay.
Testing.
Yes. How did he do, Veronica? Mr. Riley, come up.
Counsel.
Mr. Riley, he tested negative? Okay, great. One more time. 3 strikes, you're out. I don't care what your excuse is. Do you understand? Okay, all right, we'll continue it. So we're now at 4.5 months. Where are we going with this case?
I'm going to back to talk to the state on this case and one more. We'll have a resolution.
Do you have an offer on this case?
I believe there is he's got being considered.
Okay, this is way too much drama for me. So you've got 2 weeks. Figure out what you guys want to do.
Sometime after trial.
Did you talk to Bernadette?
Initially.
Well, take your time, but I mean, it's just way too much drama. It's bond violation after bond violations, just really. I'm up to here. Do you understand? Any further issues, it's not going to go well between us. Please take a seat.
Oh, I'll talk to you guys.
Okay.
Can I have this slide right on that?
Okay.
She was denied ATI. I'm going to get an offer, just needs some time for her to get the offer.
We'll give you a week. A week? You're 190 days old. And it's a first, usually it's pretty. Okay, thank you. Come on up. Hi, Mr. Strauss. Do you have a plea? Am I right? Okay. List, come up. And Mr. List, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. This charge will now go on your record. It will be there for the rest of your life. Is this a PTI that's been kicked out?
We talked about it, no, it's not PTI, no, we just said we wanted to.
How does it, 500, nearly
Well, he was a
600?
bond officer for about 180 days.
Got it. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. From now on, it is a minimum of 30 days in jail. Do you understand? I am going to, or how do you plead to the offense, guilty or not guilty? I'm going to find you guilty. I will follow this agreement. I'm going to suspend your license for 180 days. Good luck, sir. Thanks.
Can we consider 90 days?
No,
Okay.
his case is 600 days old. He took off. Why would we? No, I'll waive the court costs, but he's getting a 6-month suspension.
Yes, sir.
All right, good luck.
Hey,
Mr. McMillian, correct?
okay. McMillian, come up.
Page 12.
Thanks.
Okay.
Mr. McMillian, charged with theft, you're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail with credit for the 2 days that you've done. You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. How do you plead to this offense, guilty or not guilty? The UCW is being dismissed.
As part of the agreement. Your Honor.
Okay, what about the weapons being forfeited?
I was not.
Every time we have something like a UCW, we always need to consider what's going to happen with the weapon, please. Okay? So
I mean,
what do you think?
We'd like to have the.
It's being forfeited. Your Honor.
Yes, you're right.
Got it. The weapon is being forfeited, Mr. McMillan. You're not going to get it back. Do you understand? How do you plead to the offense of theft, guilty or not guilty? If you're not guilty, don't say guilty, because once you do this, it is a lifetime decision. You cannot unring the bell, as they say. Don't plead guilty because, this isn't Target where you can just return it because you don't like it. It's a lifetime decision that you make today. Not only that, a theft case is an enhanceable offense, meaning if you continue to pick them up, you're looking at a felony offense. You have already won, so your very well next one may be a felony offense. What would you like to do?
I want to know why I'm not offered this why wasn't I offered this?
I cannot give you the reason, but many times DAs take a lot of things into account. And you cannot continue to pick up criminal cases and expect good things to happen. It just doesn't work like that. You don't get your way in the criminal courthouse. Here we are, this is 1, 2, 3. You've now picked up 4 and 5. So at some point, they have to make a decision on what they want to do. I can't control the decisions on what they want to do. It's just, you either accept the plea bargain agreement if you don't like it. You can either set it for trial, you can counter, but it's up to them what they want to offer. They don't have to offer anything. Well, at some point, I guess, right? But it's up to you whether you want to take it. If you want, I can give you a little bit more time, but it's a lifetime decision that you make today. I'm not gonna just, these are, no, it's okay. Don't worry about it. I mean, I want you to be informed or be able to make an informed decision so that when you walk out of here, you know exactly what's going to happen, because I don't want you to come back and complaining, well, this and this and that. No, you need to know exactly what happens with every step of all the cases that you have. Criminal history, circumstances of the offense, how much, all these things go into consideration when they make plea bargain offers. So do you want a little bit more time? Do you want to continue with this? You tell me. I'm happy to give you, if you want more time, a little bit more to talk to Mr. Reed. If you want a week, I'm happy to give you a week, but you tell me.
And I'm not offered to, I don't get the privilege to get professional deferred.
That's not my decision. It's their decision, and they're the ones who make the the agreements, whether they want to offer, Right. The offer is time served, meaning that you're walking out of here today. You will end up with a theft conviction. They're going to dismiss the unlawful carrying of a weapon. As part of the agreement, also forfeiture of the weapon is also what they would like as well. Yeah, okay, so how do you plead to the offense, guilty or not guilty? I'm gonna find you guilty, I will follow this agreement, I will sentence you to it, I'm gonna roll your court costs so you won't owe anything, but understand, this now makes how many? The more you pick up, the worse it is. All we want our streets to be safe. We want to protect our community. We'll do everything in our power to do it. We're not asking for much. Do you understand?
I'm not talking.
Well, picking up criminal cases is the thing. And Mr. McMillian, you are now facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand that? It's a minimum of 90 days in jail because every conviction can be used to enhance punishment. On a first, it's 30 days. On a second, it's 90. If you pick up a class A and you have a prior, it's a minimum of 90 on one. Do you understand? Good luck.
Thank you.
All right. Okay. Hi.
Good morning, Judge. I have two fugitive cases. I explained the process of my recommendation, but for Mr. Charles,
Okay.
he would like a bond. So we are asking for a $15,000 bond.
State's requesting no bond. He is one out of Orange County for second-degree murder with a aggravated battery.
Does the murder case carry a life sentence?
No, it does not. But he also has 20
Really?
pages of criminal history.
It's okay. I'm not gonna really.
So
You never know until you ask.
let me know if he wants to wait for that.
But no, not on a murder case.
Understood.
Yeah. Who's next?
Second one is Mr. Quinn.
Okay.
Guyen. On that one, we're asking for a $2,500 bond. I think what he's currently with the.
What's your position on the
So
bond?
normally I wouldn't be opposed because there were the checks offenses, but when looking him up, he has recently been, he's recently been charged with engaging in organized criminal activity, so basically a legal case. 2 gambling promotions, keeping a gambling place, money laundering over $300,000, a possession gambling device, and all those are charged in 2024, or December 2024, so right at the end of 2024.
Are those, they're not open, are they?
No, they're open, that's what I mean.
Oh, they're open.
So, and I guess he's on bond because of Warren, that's out of Sabine County, and obviously this is from Louisiana, so I don't know if it connects, but obviously having so many serious felonies open concurrently with the Louisiana extradition.
Yeah, so I'm,
Agreed. I would just say, I mean, if he's on bond for all those, just not one. I mean, he's willing to go turn himself into Louisiana. and his
have
wife
you
is
spoken to the
on board.
demanding jurisdiction on those cases to see what's up with those?
No, I haven't followed up. I mean, they just confirmed the warrant. so-
Until I know whether, if he's really on bond, if those are in warrant status, are they looking from over there?
Oh, Sabine isn't wanting, there's no intrastate transfer. This is only in the interstate from Louisiana. So Sabine doesn't have a warrant there. I don't know what the next state is because I haven't reached there to them, but this is only pertaining to the Louisiana extradition.
So he's on bond for those?
Yes, in Sabine County. So, I mean, I haven't followed up with Calcasieu Parish, but obviously I can this afternoon. This morning's just been a little chaotic. But he did waive, so if he does not,
Do you know the amount?
I don't, I wasn't able to. Actually, I don't think it's put in the top side of it. I don't believe it's on there. Double check that.
I don't know. That's a lot.
Agreed. I mean, he's not bond revoked on those cases, so I think that's a good sign.
How old are these? Is this new?
Sorry, not the wrong one. From October 24th, 2025, they're requesting a bond. It does not have an amount. But the extradition lieutenant did confirm from Louisiana. So I can check the Sabine County, but I would.
Can you just, so you don't know the amount of the worthless checks, do you?
I do not. No, I can stand down and.
Yeah, can you find out?
I can.
If it's like 100,000 or 80,000, but if it's minuscule, then yes, I'll give you.
For what it's worth, whenever they're nominal, they're pretty good about canceling before, or at least after they confirm, they go.
I'm curious to see whether it's an amount that's just uptight and out of sight.
Okay, let me do
Yeah,
that.
just let me know. Okay. Herman,
Judge,
Hey.
Ms. Watson, prosecutor before that, 7th,
had her waiting there. She wasn't like anywhere. They were drawing her earlier. They still haven't, they don't know if they're having a hearing or not upstairs, but she's here. I wanted to make sure that there wasn't any issues with.
Well, let's go send her to test now.
Okay, well, let's send her to check.
Yeah, but it's so late now that we'll have to roll it till tomorrow. So
She's in, yeah.
I get
She's in
it.
from out of state.
I understand, but I mean,
They kept her there. It wasn't, how about if we get a negative test today, that she doesn't have to go tomorrow, come back tomorrow? Is that okay?
what's the last name?
Watson?
Miss Watson, come up. She didn't miss a test. She just tested positive and now we're doing this
That's my understanding.
confirm. Okay. Yeah, I'm down. If she's negative, then yeah, we're
Okay,
good.
cool.
Yeah.
All right.
Okay.
Well,
If not, then she'll have to come back and we'll talk.
So tentatively, what I understand is as long as she tests positive, we'll give her a date for tomorrow tentatively. And then if she tests negative, she will not have to come back.
Correct.
Be able to reset.
Yes, absolutely. Yes.
Judge, bottom of 6, how much?
A week, 1 week. Hi. Hey.
Oh, so the 20 day.
Okay.
I just signed on to the case, but from my understanding, it's pretty old.
Where's Miss Tolliver now?
She's.
Come up, Miss Tolliver. Is discovery complete on this case? Yeah. Okay. You have missed court multiple times. If you miss court again, I'm going to add a couple zeros to the end of your case, ma'am. Your case is 220 days old. You're Miss Tolliver, correct? Charged with assault of a family member? Right. This case is 220 days old. We set cases for trial at 180. I'm giving you one setting to determine what you guys want to do. At the next setting, you must be back and let us know whether you want to accept a plea bargain agreement or I will set your case for trial. If you miss court again, I'm going to revoke your bond and I'm going to go bananas on it. Do you understand? Okay. You are not to have contact with the complaining witness in this case, not to be in possession of any weapons. The MOA will be re-entered in now. Do not have any contact with this person. Otherwise, likewise, I will revoke the bond. For now, we'll have you sign all the documents and after that, you'll be free to go and we'll see you in 30 days.
I do have a question, yeah. She did
Shoot.
let me know that the plaintiff witness does stay with her.
We don't know anything about the complaining witness. This case is super old. There have been multiple FTAs. I'm ready to put it to bed,
But there
really.
hasn't been any issues and things like that.
How do I know that? All I know is that she's been gone. It's now 220 days old. There are multiple non-appearances. I don't know anything. So all I know is that, so for now, we'll have you sign the documents and then we'll see you in 30 days.
Thank you.
Please, thanks.
Yes, state's bond petition?
Yeah,
We haven't done any files.
Sorry?
We haven't done any files.
yeah. Oh, no. We have, can you redo the other one?
No, we need to.
Okay, can you file a new one? In this, in Ms. Tolliver, hey, they need to sign a new MOA, so she can't go yet. Okay, Mr. Reyes,
Hey, Judge,
hi.
I have Eduardo Garcia, you are back on the docket again today.
Got it.
And he's the one that's been on probation for 18 months and.
Sure, I
Had
remember.
him up here in mountains because he went to go work out at and whatnot. Luckily, he had a strand divine. So last time we were here approaching because he stopped at a gas station on the way back from Beaumont. So you admonished him about that, not to stop anywhere. So now with the I'm trying to keep him on the probation. He only has 6 more months left on the DWI probation. He has the scram device.
Mr. Reyes, I'm sorry. He picked up a felony assault. It's his second felony assault of a peace officer. I just don't think it's a good idea.
To keep him on probation.
Correct.
After the 6 months.
Correct.
Well, we can unsatisfactorily terminate him and.
No. I understand what you're saying, right? But DWI, fleeing and eluding, interference, assault, DWI, and now another assault. At some point, we become an enabler. If we continue to, there has to be a consequence. I am all about trying to be as nice as possible. But when you're working 1, 2, 3, 4, 5, 6, 7 on 8 violent.
Well, should there?
I understand you're doing what you need to do to the best of your ability, but I just don't think it's a good idea.
Well, looking at, I mean, this is a facility that he has to be there.
We did express with him, and the results came back that she wanted for him to go to this year.
Great. If you want it to continue, then I think that's the right thing.
Okay. I was hoping we could be getting some program with an outpatient treatment as opposed to the inpatient treatment. Okay.
Every time we deviate from the TRAS, we pay for it dearly. So if he wants to, we can do that. Otherwise, it's.
What would you consider doing?
I don't know. I need to think about it, but it's going to be.
In jail?
What?
30 days in jail?
No.
What were you thinking, 60? 90? 120? Equal. 4 times 4 is 60, 4 months is
It's
160.
going to be considerate because he needs to understand that really, it's just, yeah.
60 days.
Mhm.
Talk to him here.
Oh, no. It's like more.
Oh, more than 4 months?
Yeah.
Like 5 months?
Remember, whatever happens, they usually give him 3-for-1 credit regardless. So
Still 5 times. Would you?
no. Let me talk to them and then we'll figure it out.
So, okay.
Okay.
All right.
All right.
Thanks, Judge.
Okay. Ms. Jones, are you ready?
May I approach?
Please.
Mr. Delasco?
Yes.
So on Mr. Delasco, Judge, we got this new TRAS, okay, and they are recommending that. But Mr. Delasco is already poised to do the sober court. I've spoken with the state and the alternative would be obviously a jail plea. We both agree that sober court would be a better option, Judge. I just would ask that the court leave status as a tool for sober court to use, so that Mr. Delasco could be transferred to sober court, be given the resources there to, become sober and obtain sobriety. And if he's non-responsive with all those resources, they can use status.
And that was my suggestion, Judge. Like, that was, my concern is if we put him in SATIF now, he is going to have too much credit in SATIF that sober court will not be able to use him. Like, they won't be able to even help him because there is no punishment on the backside that if he violates, that they haven't even used.
Well, jail time.
Well, SATIF will count towards his credit, and so he will run out of time for them to use before they can get into the substantive part of the treatment. So if they put him into sober court and they say, hey, here's what we've got to get you to start following, if he violates, then they get to start using things like SATIF. If he's already doing that before he gets into sober court, he's already exhausted all he's doing.
But let me ask you this, though. What about the 5 bond violations that he's had?
I don't disagree, but I think that's part of his addiction. I think that's what has to be addressed. Until he can get into sober court and start getting those resources and people start helping him, I don't think he is, I don't want to say can't be held accountable for that. That's ridiculous. I'm just saying that I think that we've got to give him the opportunity to show that he can do it. And if he can't, then they get to use SATIF at their will.
And then
And we can do jail offer, which has already been offered.
No, I know, but I don't think that's a good
I
idea.
agree.
Yeah.
I just, we know what's going to happen. I mean, it's a slow plea to felony court.
The bond violations, I don't want to discredit that at all. I just think he's at that age. And his addiction is making him not have the life skills to be able to start addressing that. And until we can get him in the sober court to get those resources, I just don't think he's going to be productive.
How do we work it to where, because one of the issues is,
You got some people orientation.
right,
that's what I was about to, I was going to see what your appetite was for what we were, proposing, Judge, but
I mean, I guess I'm down, but the problem is that, I'm not going to give him a PR bond.
Okay, Judge, but we consider lowering his bond because.
Yeah, I mean, we have to, but what do we do if he, right, okay, great.
Do scram, get him in to see how quickly we can get him into the orientation.
It's money first.
That system is so,
I mean, that's around the corner. I think it probably needs to be I don't want to say an admonishment, so don't take that the way I'm going to say that. I think we should probably bring the defendant out, have a come to Jesus meeting with him, have a conversation.
Done that 4 times
I know,
already.
yeah, but the rubber has met the road.
Yeah, this is what we're doing.
You're gonna go.
No, okay, right. I'm not letting him out today, though. If orientation's on the 21st, what day's the 21st?
That's the
6 days, yeah.
Okay, so we'll let him out Monday, the day before. I'm not going to trust him to be over the weekend and.
Well, the jail takes 8 to 12 hours to out process it. So if he's released on Monday, that he gets spit out either late Monday night or early Tuesday morning. And then.
What time is orientation?
11.
He can make it.
Okay.
Bond violation after bond violation after bond violation after bond violation after bond violation.
He's battling addiction. Thank you.
I get it. I understand. I understand. And I want to go. I want to be with you, but I don't want to give him any more leash than's absolutely necessary because I don't want him to violate conditions again.
I understand, Judge, and that's why I actually discouraged him bonding out while I worked out this.
Guys, can you bring him out?
This arrangement, Judge. However, he does still have employment to get to. He does still have those things as well. So it's like, if we leave him in custody so long that he comes back to non-employment housing issues, I feel like I'm more so creating additional barriers to sobriety as well, Judge. So if the court is not comfortable with giving him a PR bond, as you said, until Monday, would you consider lowering the bond? So
Yes,
that
of
there's at
course.
least the option,
Yes,
if you want to
absolutely.
take it out,
Mhm,
okay?
mhm.
And if not, you have to wait till Monday.
Mhm.
Okay, what would the court consider?
What do you think, Bernadette? What's reasonable?
A young 19
What are you thinking, Stinking?
Yeah.
I'm 50 right now.
What do you think?
I was gonna ask if you would set it in half, Judge.
Oh, it's going to go a lot lower than that.
Yeah, I was gonna say 10.
Yeah.
I was gonna say 10.
Okay, that'd be better. Thank you.
You get all the reasonableness.
How's jail?
It's awesome for everyone else.
We want our streets safe. And the last thing that we want is for you to make an irreparable decision, digging yourself such a hole that your butt will never crawl out. When you're 18 or 19 and you continue over and over and over, it is a recipe for disaster. And you are literally running to prison. That's what you do. What we have now is we're trying to prevent that from happening. And you're your own worst enemy, right? If you want to do things, stay home. If you've got to go out, take an Uber. life is not hard when you make the right decisions. And when you do over and over, we as judges, as defense lawyers, as prosecutors, we see the writing on the wall. How many intoxication manslaughters are happening right now? So, guys, you want to let him know what the roadmap is?
Yes.
Let him know.
Just like we discussed, the plan is for you to be able to get them to go through the orientation for sober. That is agreement to lower your bond to 10,000. If you can make that bond, then you'll get out. You'll still follow your bond conditions. You'll attend orientation on the 23rd and enter yourself. If you can't make that bond, you'll get a PR on Monday, the day before orientation. In the meantime, when you enter sober court, if you're not able to do all the things we discussed, they're going to send you to rehab. And the rehab ranges, like you could be in there for 3 months, 6 months, 12 months until you get it right.
Year and a half. So,
Judge, I think what I want Mr. Nolasco to understand from our end is the TRAS has already recommended that he do inpatient now. And what we're all doing is taking a risk for him to send him to sober court because we all want to see that he's going to get resources in place before he has to do any kind of inpatient treatment. So I want him to understand that we're all giving him an opportunity to address this without having to go into this inpatient treatment that keeps him in custody for a longer period of time. And he has an opportunity to do that, but that's all going to be up to him.
Mr. Nolasco, we have clinicians that interview you to decide what is the best road for you. Based on your first DWI, based on your second DWI, based on the 4 to 5 bond violations that you have with us now, their recommendation is immediate inpatient treatment facility in the jail. How long is the wait to get a bed? Is it like 2 weeks?
About 3 weeks.
You would sit in jail 3 weeks waiting for a freaking bed just to get into the rehab program. And every time we deviate from what they recommend, we pay for it dearly. Meaning, when I go against what they recommend, it always ends up worse. They have, both of them, including the prosecutor, have chipped away at me to do sober court, to use this as a punishment for you in the event that you violate conditions again. And I will very reluctantly agree. But if there are any more violations, and I don't care how minute you think it is, this is what you will be facing. It's a 3-week wait just to get a bed in the facility. And if you respond well to treatment, it could be a minimum of 9 months to a year and a half if you don't respond well to treatment. You and only you hold the keys to this cell. Do you understand? So when your friends start coming around and, hey man, let's go hang out. And you know that they're going to do something crappy. Don't go, because you know it's not going to end well. Do you speak Spanish?
No, sir.
My mom used to tell me, dime con quien andas, yo te digo quién eres. Tell me who you hang out with, and I'll tell you who you are. They will lead you down the wrong path because they don't care. They're not the one facing a year and a half in a facility. Do you understand?
Yes, sir.
We will not have this conversation again. One more violation, that's it. All the same conditions will continue. So he gets a scram on one ankle. He gets an ankle monitor on the other with a curfew of 9 p.m. to 6 a.m. No drugs, no alcohol, weekly testing. What?
For the ankle monitor, the curfew, can we do 8 p.m.?
Sure.
Because he needs time to get on.
No. I'm not letting him out in the middle of the night.
I'm saying the curfew be 8
Back
p.m.
by 8 p.m.
Be back by 8 p.m.
Oh, sure.
So that he can get home and not be in constant violation
Okay.
if he's cutting it close.
You mean, because I was saying 9 p.m.
Oh.
to 6
That's
a.m.
even better. That's better. I thought you were saying 6 p.m.
No. 9 p.m. to 6 a.m. He's got to be home by 9 o'clock at night.
That's fine.
But if he comes home at 9:01, if you fail to show up for a drug or alcohol test, an immediate warrant will be issued. Do you understand? Okay, so lower the bond, please, to 10,005. So, yeah, let them have, let them have, please. Okay, all right, are we good?
Yeah, Judge, thank you.
Okay, all right, thanks, guys.
Thank you.
So we're bringing them back on Monday?
I don't know that he's gonna be able to make that bond, so I don't think we necessarily need to bring it back. I could just appear and approach on the bond, just have to build it up.
Sure, yeah.
So he's getting the bond now.
What? No, I set the bond at 10,005.
But if he's still in custody, I'll approach on Monday.
She'll approach on Monday for a PR bond, and then I'll give him a PR bond on Monday. And then, I guess,
Because most likely, I don't know if they'll even be able to make it at home. So I'll still just approach first thing Monday for Zoom on if I need to.
sure,
Get him.
of course.
Yeah, I'd say do that as early as you can,
That's why I was saying, yeah,
just to make sure that he's released in time to make it.
Oh, if I give him a PR bond, he'll be out within, yeah.
not that night, probably.
Yeah, I think so.
Oh, yeah.
Okay,
He just can't miss orientation.
I know.
Should we set the case for Wednesday, just to make sure that he showed up?
Sure. Yes, that.
Yeah, what do you think? You okay with that? Okay, all right.
Thanks,
So,
Judge.
all right, okay, guys.
I really appreciate your grace.
Hey, get your brother, man. Get your boy. Really. Ready? Hey.
I'll leave on docket.
Okay. Jail or bond?
I'm searching for a PR bond judge. He currently has an AFM and he has an interference charge. The dad is the complaining witness and the AFM, and he has reached out to me through email, through phone, saying that he does not want to move forward with the charges. He's also reached out to the DA's office and spoke to Giselle Perez and communicated that he did not want to go forward with the charges. She emailed him back on April 6th and said that she has forwarded that email to the DA. I spoke with the DA on Monday. They were supposed to do a RIP call. That has not been done, so his case was reset to today. The RIP call has still not been completed. As of right now, we have a treatment plan in place. He has benefits and they expire on Monday. Right now, he has a confirmed appointment with Quest Diagnostics for April 18th. And then he also has a confirmed appointment with Gulf Coast Center for further mental health help on April 21st, which is a Tuesday. He would need a PR bond to be released, and so that he can make those appointments and so that he does not lose his benefits. And the state is not opposed to dismissing. However, his mother, the only other person he would be able to stay with is his mother, and she is currently in North Carolina right now. And the order of protection is against his mother.
The problem is that great, give him a PR bond. Where does he go?
Exactly.
Lives on the street?
My concern is that he is waiting on a dismissal because the state needs to make RIP calls. And I reached out to DA on Monday. They were supposed to do it Monday. That did not happen. We are rolled it to Wednesday today. Still no RIP call. He contacted Giselle Perez at the DA's office and communicated that he did not want to go forward with the charges. And she said she forwarded that to the DA on Monday. So
My issue is that he is waiting in jail on a dismissal because we're waiting on a recall. We can't move him down the road.
We did give him a PR bond once, failed to appear. If I give him a PR bond now, how's he going to do anything?
If the state makes the recalls today, they're not opposed to dismissing the case. Their holdup is that
Why
they
don't
want
we-
to speak with the complainant.
Why don't we roll it till tomorrow? Or,
Are they
You
going to
tell
move the
me.
recall tomorrow? Because I moved it already.
well, let's,
Well, Judge, what I did tell her was that there was a couple of options. So you could have gotten a MHPTI to go to the hearing committee this day. And
That's a great
she did tell
idea.
us- She did also tell us that there was the option of him staying with his mother. So there were a couple of places for him to go while the state did get a rip call out to the defendant's father. So there were a couple of options. I'm not sure which one she's had the.
what about the release of the hair center?
Because of the AFM, I do not think that they will take him underneath that charge.
They will,
And
they
also,
will. We
he
do
has
it all the time.
appointments scheduled that he can get more comprehensive care through because he has benefits. He's going to Quest Diagnostics to get blood work done so that on Tuesday when he goes to Gold Coast, they will review
Ms.
his blood
Strong,
work.
how is he going to get anywhere?
If the cases are dismissed, the state is not opposed to dismissing the cases. My position here is that we're waiting on a dismissal for them to make a recall when their office has already been notified that the complaining witness does not want to go forward with charges. They were supposed to do it
But
Monday.
imagine how many thousands of cases they have.
I have
You
a lot
know,
of
we
cases too,
have
Judge.
given him the opportunity and just,
I understand. Monday, the recall was not made. They said that they will make it.
I
rolled
get it.
Till Wednesday.
but she offered an alternate reasonable resolution, getting him to the hair center where they can provide him with resources and can provide him with a bed as well. They can provide him with temporary shelter.
I understand, Judge. However, in the long term, he needs to get his injection through the Gold Coast Center. If we're doing a workaround, he's just gonna go to the hair center, for a couple of days to give them time to make a road call, then dismiss? Or
If we
they,
let him out now, he's going to the street.
if they dismiss today, then he will be able to go to his father's home.
So again, Judge, even with the PTI, he still goes to a bed and he still has access to his mom. And
Well,
so-
I guess his mother, I just found out, his father just confirmed that currently, right now, his mother is in North Carolina.
Can you think you can get it done later today?
Why don't I step out at future cases? I can do it on their trial.
Right.
Can you give them a little bit of time? We'll try to reach out today.
Okay, if they reach out today, it's just, you guys are gonna dismiss.
It's a big
I haven't
ask.
waited. We were waiting on the state to make a clause. He is in custody because they need to make a recall. I gave them.
He's in custody because he failed to appear for court.
They're not opposed to dismissing the case. I spoke with the DA Monday. That recall was supposed to be done, and I agreed to reach that to Wednesday. I gave them 48 hours to make a 2-minute.
They're gonna go do it now.
Judge, to be clear, I told her on Monday that we start trial next day and that I couldn't promise I'd get it done at 4:30.
And I told the defense as well, I said, let us finish with the trial and we'll get it done. I just needed the time.
They'll get it done today.
The recall will be done today. At what time?
Yes,
Ariel.
that's a yes.
At what time, Judge?
Well,
Ariel, we cannot promise you what time. We will get it done.
Ariel, it's gonna get done today. It'll get done today. It'll get done today.
Monday. The DA's office, the Victim Services, was already made aware on April 6th that his father did not want to go through with the charges, and it was sent to the DA.
I will make you a deal. If it's not done today, I'll give him a PR bond tomorrow.
Thank you, Judge.
All right. Thank you for your zealous advocacy. You're doing great.
Thank you, Judge.
Yes, ma'am.
Well, we'll see what happens.
Hey, come on.
Hello again.
Hey,
Back on both cases, Judge.
okay.
So on Mr. Nguyen, I think my ask was 2,500. We left off wondering how much these checks were.
$30,000 from the Golden Nugget, and obviously in context with the gambling, washing checks. It's not great. The OCA.
It's not gonna be that. With all the stuff that he has open, no, it's gonna be high. Because there's a big, yeah, it's,
And for what it's worth, it is Calcasieu Parish, so they're gonna be coming this week. It's Louisiana.
do you want to let him know? Is he going to, spend all this money to get out when they'll probably pick him up within the next 2 days?
I have tried to explain that to both of them over and over. Perhaps it would
Sure.
land differently.
Can you bring them both out?
That's,
Wow.
the other one is Charles, but Lynn is the one you said went back.
Yes, why went back? So
Dang.
you want to kill him and and you just.
If you want to meet in the middle, if you want to talk to your client after docket, and then if you want to see each other tomorrow.
You can do that? Charles, it's not going to happen. He's wanted for second degree murder and then some other, that's just,
We're pushing for that for a different reason. It's one of those where he wants to keep the refusal for the governor's warrant. He wants to stick it out for the 90 days. So I think it's worth admonishing at least for the full range of consequences if we go that route.
okay. You want to roll him to tomorrow?
Sure,
Do
we'll
it.
roll with it.
Yeah.
And if you could please admonish Mr. Charles.
Right now? Is he here? Did they
Yes,
say he's
he
still
is.
here?
I just didn't know if you were about to start right now.
No, yeah, I want to. Can you,
Real quick, bottom of 2,
yeah,
council called and said he was in the hospital with his dad. How much time do you want me to?
on bottom of 2,
Yes, Judge. The veteran is here.
the defendant's here. A couple days? Monday? Let me, well, hey, well, bring him out. All right. Good morning, Mr. Charles. Sir, you were wanted out of the state of, several things you have to understand. All right, I'm sure you do, but, here in Houston, every single day someone's dying. There's just so much drama on our streets. And it really scares me what happens, what's going on a daily basis here. And I just, you're wanted for second degree murder with a firearm and attempted battery with a firearm. I just don't think it would be a good idea to give you a bond. Do you understand?
No.
Okay, well, that's okay. You don't have to. But the reality is you kind of scare me. And so I don't think, well, the charges are pretty, and so, and what else? Does he have any other criminal
So he
history?
has 22 pages of criminal history. He's convicted in 2019 of possession of a weapon by a felon, a firearm by a felon. He's convicted of having possessing ammunition by a felon. He was recently bond forfeited and had a warrant out for his arrest in 2023 for an indecency with a child. That case was later dismissed, but I'm only pointing out that obviously he was supposed to comply with bond conditions, and he had a warrant out for his arrest in 2023 for not complying with court conditions. So among those, he was charged with multiple domestics, burglaries, and again, I can read you the whole 22 pages, but a significant number of them have been dismissed, but based on the timing, I don't know if it was in consideration of the pleas, and I can go through it if you like, but 22 pages.
You understand? 22 pages of criminal history. At some point, we just got to say when. We can't just. So you have multiple options now. You can waive extradition. If you waive extradition and Florida doesn't come get you, Harris County will release you. However, those warrants will always remain in effect until you take care of them. The other thing you can do is refuse extradition, which in that case, they can get a governor's warrant from the state of Florida, and at that point, force you to go back to Florida. Do you understand?
So the 90 days that we talked about, that process would essentially.
So, right, they get a warrant, a governor's warrant from Florida, remanding you to the custody of marshals from Florida, and then they will take you back.
No, they will.
Have they indicated?
They want, and it's a
Florida has already indicated to the state's prosecution that they want you, so that they're going to come. So whether it's within 14 days, whether it's 90 days, that's up to you. I don't want you to decide now. I'll give you time. I just wanted to bring you out to let you know the options so that can make it.
Trying to get a bond, so, yeah.
I'm not going to give you a bond, Mr. Charles. You
Right,
just-
so basically, I'm going to find a way so I can go ahead and deal with this. This is not right.
Right. So, I mean, that way, just go back, just get it once and for all, looking over your shoulder, really, just
It's not right. Yeah, so-
look, you don't have to say anything. It doesn't matter. Just, we want to know how to go forward and, that way you can go ahead and just move on with everything, Yeah, it's a lot. Okay? All right. Thank you, sir. Good luck.
Thank you, Judge.
Thanks, guys.
Judge Pampered.
Yeah.
Quick question on bond conditions for Colvinson. I didn't get a note of the bond conditions.
I said no conditions no condition. The fleeing?
Yes.
Yeah, no condition. It was just,
For Culbertson?
uh-huh.
Judge, you said the Moab, and I thought it was.
No, that's a different person. Do you have a plea?
Yes, please, Judge.
You ready?
Yes, we're ready.
Come on, bring it.
Mr. Jackson.
What's his last name?
Jackson.
That's okay. There's a DWI, there's a weapon with this case,
Yes,
right?
they were on this down and
And-
forfeiture.
Right, that's my concern. Okay.
Yes.
All right. Right, Mr. Jackson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. You've worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you've done. You are giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this plea of guilty, this will go on your record. It will be there forever and a day. From now on, it's a minimum of 30 days in jail for any new cases that you pick up. Do you understand? How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will follow this agreement. I have to suspend your license. I will do it for the minimum, which is 90 days. Do not drive until you get a license, and good luck to you, sir.
Thank you, Judge.
And
We
we'll-
waive the surcharge?
Yeah.
Thanks, Judge.
Yeah.
Judge, can I go over like briefly?
Yeah, come on.
Top of 16, you were both here yesterday for VDR.
5,001.
All right, next is bottom of 19, and then it goes to appear.
5,001. And can you guys put the motion to revoke?
Oh,
Withdraw, sorry.
Yes.
On bottom of page 19, Urbina, you file a motion to withdraw.
Yes.
Okay.
Well, I think, y'all were talking about George's case. We won't get into that one. Garcia on 7.
Just set it, I guess, a couple weeks. When is felony court, do you know?
5:13.
I guess set it for the day after, or whatever he wants. And then at that point, we'll set it for a hearing.
All right, for the jury.
Sorry to keep you guys, please be seated. I'm so sorry to keep you guys waiting. We have quite a bit of, we still have other business that we still attend to while we're in trial. So we'll try to be as efficient as possible. Okay, State, are you ready for your next witness?
Yes, sir.
Okay, do you mind calling him up?
Yes, sir. And this time, the state calls Officer Roy.
All right. All right, come on up, officer. If you don't mind raising your right hand to be sworn, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir, I do.
All right, come on up. All right, Deputy, I'm going to ask you, please, if you don't mind, speak clearly, loudly. If you hear the word objection, just stop. Once we've addressed it, at that point, you may continue. Okay? All right.
Morning, Officer Moore. Good morning. Can you please introduce yourself?
My name is Brian Rohr.
And how are you presently employed?
I am currently a police officer with the Pasadena Police Department.
What got you into being a police officer?
I ended up leaving the military and found that I didn't have any other skill sets, so I became a police officer.
And how long have you been in office then?
I've been here for about 5 years.
And where are you currently an officer at?
With the Pasadena Police Department.
With Pasadena, what's your current assignment?
I'm currently assigned to our DWI task force.
What is that?
It's a specialized division that we offer that specifically deals with driving while intoxicated.
What are your duties on your current assignment?
Duties are, excuse me, traffic control and enforcement mainly, as well as detection and investigation of possible intoxication in drivers.
So what does a typical day or night look like for you?
A typical day is a lot of driving around, lots and lots of circles around the city, observing typical moving behaviors that might indicate possible intoxication, contacting drivers to determine if a DWI investigation is necessary, or in some cases, performing DWI investigations as requested by other officers.
On July 25th, 2025, what was your assignment that night?
I was also on that date assigned to the DWI task force working night shift patrol.
And how long were you on that assignment?
My division works 10-hour shifts.
Okay, so now I want to talk a little bit about the training that you had to undergo to become a police officer. So what kind of training did you have to go through before you ended up at Pasadena Police Department?
So the basic police officer course is mandated by the overarching TCOL, which is the Texas Commission on Law Enforcement, which requires so many hours to be completed to obtain a basic police officer's license.
So becoming certified, did you have to go through classroom and field training?
Classroom and field training. Our academy was about 8 months long. Field training was another 3.5 months after that.
What does the classroom training look like?
Classroom training is a significant amount of time, several months. At Pasadena offers our own academy, but there are also private academies around, and you go through a significant amount of courses ranging from just basic CCP, become an SST practitioner, and just the basic skill set to be an officer.
And then outside of the classroom, what does the field training look like?
The field training is you are working on the street, doing the actual job with a field training officer who rides with you, observes, make sure you're doing the job adequately, and gives you proper feedback into your performance.
What kind of training did you receive regarding DWIs?
During the basic course, you do go through a basic SST practitioner course, which does certify you as a basic SST practitioner, which gives you the ability to administer the field sobriety tests.
Did you receive any additional training besides that basic course?
Yes, I did. After making it off of probation, which is the year period after your field training, I went on to become an A-Ride trained, which is kind of the next step up above SST practitioner, and went on to become a certified drug recognition expert, as well as I am now an SST instructor.
Okay. And drug recognition expert, what all does that entail?
The drug recognition expert program is the highest level of detection and investigation that we have. we learned about the 7 different drug categories, as well as the drug recognition expert evaluation process, as well as a significantly expanded repertoire of skills, observations, to articulate what the signs of impairment that we see in drivers with not only alcohol, but also drugs as well.
And being a DRE, does every officer become one?
No, when I was certified, there were fewer than 400 drug recognition experts in the state of Texas.
What's the difference between a DRE on patrol and a normal officer on patrol?
A DRE is going to have significantly more experience and knowledge, whereas a basic officer just, for instance, would give a very surface level observation, such as, just for instance, slurred speech. A DRE would be able to greatly expound on that and say, was it slurred? Was it also raspy, slow, thick-tongued? We have the ability to dive more in depth into what exactly is observed.
Okay. And when you're on patrol as a DRE for a possible DWI investigation, what additional things are you looking for?
I am also, as a DRE, we have more just experience and knowledge to observe the totality of circumstances that exist on a scene rather than becoming focused on one particular thing. Whereas a regular patrol officer may just be focused on eyes and speech, a DRE would also be looking at movements, speech patterns, if they're getting hung up on specific words or phrases, the length of time it takes to respond to an officer, and how that response is given.
Now, over the years as a DRE, how many DWI investigations have you done? Ballpark.
A significant amount. I think I've personally investigated about 350 around that number DWIs.
Okay. And in those investigations, what are some signs of intoxication that you've been trained to identify?
We look at the eyes, if they become red or watery or bloodshot. Speech patterns are a very big thing. It's very common for them to have slurred speech. Delayed reactions, odor of alcoholic beverages emanating from breath and person is also a very big clue.
Okay. Now let's talk a little bit about your involvement in this particular case while we're here. On July 25th, 2025, you said that you were working the night shift. Where were you patrolling?
I was actually up at the station for most of that night, working DWIs that had been brought in.
Okay, and when you're at the station, how does it work for someone to bring a DWI to you?
So the typical process of that is the officer would call out on the radio to see if there is a DWI task force member available. If one is not available because we are tied up currently, then that officer will transport that subject up to the police station where we do have a specific intoxication room to perform DWI investigations.
And that night, were you wearing your full uniform?
Yes, I was.
To your knowledge, was your body worn camera working?
To my knowledge, yes.
Your Honor, approach please.
Yes.
Officer Rohr, I'm approaching what's been marked as State's Exhibit 3. Do you recognize it?
Yes, I do.
And what is it?
That is a CD containing my body-worn camera footage.
Before your testimony today, have you had an opportunity to do it?
Yes, I have.
And how do you know it's yours?
Because my signature is right there on this.
To your knowledge, has it been altered in any way?
No.
At this time, state offers State's Exhibit 3 for the tendering for inspection.
It'll be admitted. So that's 3 body worn camera?
Yes, Judge.
Okay.
Now, Officer Rohr, That night when you're at the station, did you ever come in contact with someone named Alejandro Gonzalez?
Yes,
You seen him work today?
I do.
Can you please identify him by article of clothing that he's wearing?
The gentleman in the red flag shirt.
I made the record reflect what is identified.
So reflect.
Now, where did you first meet the defendant?
That would be back in the intoxication room at the police department.
Okay. Were you called to conduct a DWI investigation that day?
Yes, I was.
Were you able to respond on scene?
I was not.
Why is that?
I would have been working a prior DWI already.
Okay. Why was Officer Escobar bringing the defendant to the station?
He would have brought up the defendant because he believed that he detected while on scene that the defendant was displaying signs of possible intoxication.
And what was the name of the room that you do your investigation in?
The official name is Interview Room 2. We call it Room 2 for short. It is used as essentially the DWI Task Force office.
Okay. Why would you take him to Room 2 when he brought him?
That particular room is set up as the most conducive area that we could possibly create to adequately and without problem administer the standard field sobriety tests.
Now, when you first met the defendant, what all did you notice about him?
I did notice that his eyes were red and bloodshot. He did display some slurred speech. I noticed he also had a sway in his stance, and I could detect an odor of alcoholic beverages emanating from his breath.
And as a TRE with 350 prior DWI investigations, what do those signs typically tell you?
Those signs would tell me that a DWI investigation would need to be conducted.
Did you conduct one?
Yes, I did.
Now, the whole time that the defendant or you were speaking, how would you describe his demeanor?
He was irate when he was brought in. He was not particularly cooperative at the time. He did refuse to answer questions or follow any instructions that I gave him.
Now, while you're at the station, is it a common practice of the Pasadena Police Department to make a video recording of all persons brought into that room?
Yes, it is.
Your Honor, may I first witness?
Yes.
Officer Rohr, I'm handing you what's been marked as State's Exhibit 4. Do you recognize it?
Yes, I do.
What is it?
That is a recording of the camera system from the intoxication.
Was it made at a time of the conditions of this incident?
Yes, it was.
And was it kept in the regular course of business of the Pasadena Police Department?
It was.
And have you had a chance to watch it prior to your testimony today?
Yes, I have.
To your knowledge, has it been altered in any way?
It has not.
This time, state offers states tender to defense through inspection.
Okay. He'll be admitted.
Thank you.
States 4.
So, Officer Rohr, as I'm working with technology here and loading stuff, would you mind telling us about how that investigation started in Room 2?
Officer Escobar brought the defendant in. As is her usual practice, I will, when I first make contact with the defendant, put them into a specific interview position, which is informing them they asking them to stand straight up with their feet together, arms down to their sides. Excuse me, I'm sorry. After that, if they are brought into the station and I'm not able to actually get in contact with them on scene, I'll go ahead and read them Miranda rights, just so we don't violate any rights or anything like that. And then I will go ahead and conduct my investigation, starting with an initial interview of the defendant, and then move on into the administration of the standardized field sobriety tests.
Judge, may I publish this?
Yes.
Officer, what's the purpose of that line on the right side of the room there?
That line is used in the administration of the walk and turn test, which gives them a physical line to look at on the floor instead of having to use an imaginary one.
So in the station video, can you walk us through what's happening at this point?
Right there, I'm reading some call notes, preparing to speak with him. Just kind of getting my thoughts together. Here I am asking him to come stand on the tape line on the floor right there, so I can begin the.
What's the purpose of that line, that cross line?
The cross line gives them a very specific place to stand, as well as to begin any of the SFSTs they would do.
Now, Officer Lord, why does compliance with instructions matter for a DWI investigation?
There are specific things that a DWI officer will ask a defendant to do, as well as we observe their reactions and their general demeanor and look for clues and signs of intoxication. So putting them into certain positions will kind of avoid having false positives.
Now, at this point, what instructions are you giving them?
At this point, was asking him to stand straight up with his feet together on that cross on the floor and keep his arms down to his sides so I can go ahead and begin the investigation.
Was he able to keep his feet together and his arms on his sides?
He did move out of that position multiple times and would not stay in a position that he was instructed.
What does that indicate for a DWI investigation?
That would indicate a possible inability to follow instructions.
For the record, we're pausing at 2:18. So, officer, what's the typical steps that you will have someone go through a DWI investigation? What does that look like?
Generally starting from the very beginning, I will go through an initial interview of the subjects. Especially if they're brought into the station like this, I like to ask them in their own words what had happened that night. So I can get their side of the story. I'll generally go through where are they coming from, if they asked if they consumed any alcohol that night, where they were going, typical questions. I'll also usually ask some medical questions to kind of eliminate that stuff, as in, when was the last time they slept, right? Or when was the last time that they had something to eat, right? So I can rule out some possible medical reasons for what I'm seeing.
Did you ask some of those questions in this investigation?
I did not have the opportunity.
What do you mean?
Prior to being able to ask those questions, the defendant just repeatedly told me to talk to his lawyer and refused to answer any questions that I was asked.
Now, officer, I want to walk through, well, first, while you're giving him these instructions, and we'll resume here at 2:18, and walking you through and trying to ask these questions, how is he doing on following your instructions?
He was going back and forth with me. I was giving instructions and he kept talking about the stop, as well as not maintaining the position that I told him to stand in.
When he's talking to you, do you notice anything about his breath?
Yes, I could detect from where I'm standing, which is a decent conversational distance, that there was a strong odor of alcoholic beverages emanating from this present person that I could detect from about 5 feet away.
And from that distance too, did you notice anything about his eyes?
From even in that distance, the room is very well lit for that particular reason. His eyes were very red, watery, and bloodshot.
And now, right here, what does he do with his feet?
So he has moved his feet apart. He was moving them as well before, but he is now very far out of the position that I placed him in and asked him to remain in.
And and for the record, this stopped at 3:41. When you're doing other DWI investigations, what is the expectation for someone who's receiving those instructions on a position?
The expectation would be that they comply and maintain the position that they are placed.
Okay. Now, so we've kind of hinted around SFSTs for a while here. Let's talk about it. What's the purpose of SFSTs?
The purpose of the standardized field sobriety test battery is excuse me, for the administrator to observe validated clues in the defendant that would, to a high degree of accuracy, indicate intoxication.
How many SFSTs have you performed over the years?
If I haven't passed 1,000 times administrating these tests, I'm getting pretty close. Okay.
What does standardized mean in that title, standardized field sobriety test?
The standardized in there is that there is only one way to administer these tests, and that is the standardized way as dictated by NHTSA.
And how many validated tests are there for standardized field sobriety test?
The standard SFST battery includes 3 tests.
What are those tests?
The first test is the horizontal gaze nystagmus test, which is the one we're probably all familiar with, where the officer waves something in front of someone's face. Then we move on to the walk and turn test, and then the last one is the one leg stand test.
And you said that these were all administered or approved by NHTSA. What is NHTSA?
Is the National Highway Traffic Safety Administration, the overarching national governing body for traffic.
Okay. And back to HGN, horizontal gaze nystagmus. What's the nystagmus?
Nystagmus is an involuntary jerking of the eyes. On the horizontal gaze nystagmus test, we specifically look for the horizontal gaze nystagmus, which is the involuntary jerking of the eyes as they gaze to the side.
And what can cause nystagmus?
Nystagmus in general can be caused by quite a few things. There are several different types, but it could be induced medically. It could be artificially induced, and it can be caused by intoxication.
And why is a nystagmus induced by intoxication concerning for driving?
So the nystagmus caused by intoxication is a disconnect or a lag, if you will, between the information processing received from the eye to the response from the brain. So as you're driving, if you are looking at, let's say, a stop sign, and your eyes look and they see a stop sign, and then it takes your brain a little bit of time to actually process that, hey, there is a stop sign, to send the information to your feet that says, like, stop at this stop sign, then you will more than likely overshoot that stop sign, which can be a significant problem if there is a pedestrian in a crosswalk.
And you mentioned that there were a bunch of different kinds of nystagmus. How do you eliminate other kinds from the one that you're looking for?
The position that I place people in for the interview process, one of the instructions that I give them is to stand straight up. So they are standing straight with their head straight up, and their arms down to their sides. In our particular interview room, there is nothing but a cinder block wall behind me. There is nothing moving on a horizontal plane for them to focus on. The only thing would be for them to focus on my stimulus. Before that, we do medical checks for arresting nystagmus, see if there is any type of involuntary jerking before we move the stimulus, as well as we are only checking for nystagmus on the horizontal plane.
When you're administering an HGN test, what's the first step that you do?
The very first step is the medical qualifiers. Before ever moving the stimulus, you hold up whatever you're going to use. I actually use a Streamlight red LED. I'll hold that up. I'll hold it still. I will check the eyes for equal pupil size to make sure there is no possible head injury or possible concussion that may cause jerking that I'm looking for. And I'll also check for resting nystagmus, which would indicate that there is a medical condition that may possibly cause jerking that could be misconstrued as what we were looking for. Moving on from that, the first time that we would move the stimulus would be checking for if the eyes can equally track, say for seeing if there's blindness in the eye, and if there's blindness in either eye that is unable to equally track the stimulus.
Why do you track? Why do you track or check for equal tracking?
If there is any type of blindness in either eye, or one eye moves, or one eye just doesn't, if someone has a false eye, then I would know that, okay, I don't need to be looking for clues in this particular eye because they can't see. In the case of possible blindness or anything such of the such, if that eye cannot smoothly and accurately track a stimulus as it moves across the plane, that could give a false positive as that eye is now jerking, but it's because of the blindness that it can't accurately track the stimulus.
Okay. And when you're administering an HGN test, how many components of the test are there?
There are 3 parts to the test, which do coincide with the validated clues of the test.
Okay. And what are those 3 parts?
The first part is checking for a lack of smooth pursuit in the eyes. The next part is distinct and sustained nystagmus at maximum deviation. And the last thing we check for is the onset of nystagmus prior to 45 degrees.
Now, because that's a lot of big words for me even. Let's start with the lack of smooth pursuit. How do you check for that?
So the lack of smooth pursuit, this particular part, if you will imagine just a very hot day here in Houston that's very, very dry, and we've probably all gotten in our car and accidentally activated our windshield wipers. Those wipers do not go smoothly across that very hot windshield. They skip or they'll bounce. That is exactly what the eyes will do when attempting to smoothly track an object because of the delay from the eyes to the brain.
And what is maximum deviation?
The distinct and sustained nystagmus at maximum deviation, we will move the eye to maximum deviation, which is as far over as it can look. And what we're looking for is the continued bouncing of the eye. Now, it does have to be distinct and sustained. We hold it out for a minimum of 4 seconds, and that bouncing has to continue for the entire duration that we hold the stimulus to the side.
And then what's the 45-degree mode that you mentioned?
The onset of nystagmus prior to 45 degrees is we move the stimulus very, very slowly, and we are looking for the eyes to start and continue to jerk before we reach 45 degrees. A 45 degree.
Now, when you administer this whole test, how many possible clues are there?
There are 6 possible clues. There's technically 3 validated clues, but they can be observed in both eyes.
Now, we've got a good understanding of an HGN. What is the second SFST test?
That would be the walk and turn test.
And what is that?
Starting with the walk and turn, that is the first psychophysical test of the SFST battery, where it is designed to divide their attention between a mental and physical task, just like operating a vehicle. That has them standing in the same interview position that I put them in, straight up with their feet together, hands down to their sides, and then taking 9 heel-to-toe steps along the line, turning around in a prescribed manner, and taking 9 heel-to-toe steps back along the line.
And based on your training and experience, is that test a good indicator of physical or mental impairment?
Yes, it is a very good indicator of someone who retains or has lost the mental and physical faculties required to safely operate a motor vehicle.
And how many clues can you get on a walk and turn test?
There are 8 validated clues in a walk and turn test.
And what's the third and final SFST test?
The last one in the battery is the one leg scan test.
What is that?
That involves, again, placing the subject in that same interview position, feet together, arms down to the sides. They're then instructed to raise either foot about 6 inches off the ground in front of them while keeping their legs straight and their arms down to their sides. They're then instructed to look down at the raised foot and count in a specific manner until instructed to stop.
What is that designed to assess?
Now, that is, again, the second of the psychophysical tests. Again, is designed to split the subject's concentration between a mental and physical task, just like operating a vehicle.
How does that help you determine intoxication?
So that again will determine if they still retain or have lost their mental and physical faculties required to safely operate a motor vehicle.
Okay. Now you mentioned diverted attention. Can you explain that?
Just the psychophysical portion in each of the tests they are instructed to count, which forces them to concentrate on something other than just the specific motor functions required to do the test. So just in the simple act of counting, in the walk and turn 1 to 9, counting their steps out loud, or the walk and turn, counting by 1/1000s, that does take away some mental focus in places that somewhere else, just as operating a vehicle as you're observing all of your surroundings and then acting accordingly.
And based on your training experience, why is attention diversion an important thing for DWI or driving in general?
Excuse me. I'm sure everyone in here has at very least been in a moving vehicle. We all know road conditions are constantly changing. I would say even down to the millisecond. Cars move, they come up, they go away, changing lanes, having to avoid a collision with stationary objects as well as other objects, looking at other drivers and how they're on the road so we can make sure we don't hit them, as well as just something so simple as stopping at a stoplight at a designated stopping point so we don't, say, run over the crossing guard or something like that.
Now, in this case, how many of these tests did you get to administer on the defendant?
On that day, I administered 0 of these tests.
Why not?
He refused to participate and perform the tests.
And based on your training experience and your investigations, is that typical?
That is not typical, no.
And as a DRE, with having administered these tests many times, did that tell you anything about your investigation?
That was a fairly large red flag to me, as I don't believe I've come into contact with a rational person that is going to refuse to perform those tests.
At this point in your investigation, what was the source of the defendant's impairment?
At that time, due to the strong odor of alcohol emanating from his person, at that point, I did believe there was possible intoxication due to the consumption of alcohol.
Now, after you refused to participate in these SFSTs, what did you do next?
The next step was I read in the DIC 24 statutory warning, which does explain their rights as the, excuse me, it explains how the investigation is going to proceed and their rights in consenting or refusing to provide a forensic specimen.
When you read in the DIC, did he consent?
So afterwards, he did not consent. He refused to provide the breath specimen that I requested.
Your Honor, may I approach the witness?
Yes.
Dr. Rohr, any what's been pre-marked as State's Exhibit 5. Do you recognize it?
Yes, I do.
Is that a true and correct copy of the warnings that you read the defendant that night?
Yes, it is.
And was that at the time of the events of commissions?
Yes, it is.
And was it made in the ordinary course of the Pasadena Police Department?
Yes, it was.
And is it kept in the ordinary course of the business of the Pasadena Police Department?
Yes, it is.
And has it been changed or altered in any way?
No.
This time, State offers State's Exhibit 5, tender defense.
It'll be admitted?
Judge, may I publish?
Yes.
Officer Rohr, when you're doing these investigations, is it common for people to consent to a DIC when it's read to them?
More often than not, they do consent to provide the requested specimen.
A little bit of that. Okay. Now, officer, just wanted to point out some identifying information here at the top. Whose name is in the top left?
That is the defendant's name.
Okay. And then what day was this on?
Was
a little There's one next to you as well.
Kind of small, it was the 25th of July of last year.
Okay. And then what county was it in?
We were in Harris County.
Okay. Now at the bottom here, what does this bottom checkbox mean?
So as stated in the very last paragraph, that by my signature, I certify that I have given them an opportunity to sign the form. Now, I do inform them that their signature on the DIC 24 is just a affirmation that they have been read that particular form and has no actual admittance to the commission of the crime.
Would you mind reading the box that's checked?
Yes, it says the subject refused to allow the taking of a specimen and further refused to sign below as requested by this officer.
And whose signature is at the bottom?
And that is my signature.
Now, based on your training experience, what did his refusal indicate to you?
That would, again, be a possible loss of mental faculties due to intoxication.
Okay, so now the defendants refuse to do SFSTs and refuse a breath sample, what's the next step?
The next step in the investigation was I typed up an affidavit and I submitted a search warrant for the collection of a blood specimen.
This off here. Speaking of the search warrant, let's get into that a little bit. Did you, at this point in your investigation, feel that you had sufficient evidence to draft an affidavit for a search warrant?
Yes, I did.
Why is that?
Due to the totality of circumstances, due to the driving behavior reliably relayed to me by Officer Escobar, to his signs of intoxication on scene that were also reliably relayed to me, as well as my own signs of intoxication and his demeanor and refusal of the entire process. I did feel as if I had very good grounds to move forward.
And was an affidavit for that search warrant drafted that night?
Yes, it was.
And what did you do with that affidavit after you drafted it?
After I drafted it, that is submitted over to a judge for signature. If they do agree that adequate PC exists to proceed forward with the collection of that blood specimen, then they will sign and return the search warrant.
Now, to your knowledge, is Judge Harrison a judge or magistrate in Harris County?
Yes, he is.
And did Judge Harrison review your affidavit for search warrant?
Yes, he did.
After examining your affidavit, were you granted permission to obtain a search warrant?
Yes.
Your Honor, may I first witness?
Yep.
Officer Moore, handing you what's going to be pre-marked as State's Exhibit 6. Do you recognize it?
Yes, I do.
Is that a true and correct copy of the blood search warrant that you obtained on July 25th, 2025?
Yeah.
And at the time it was executed, did you believe it was valid?
Yes, I did.
Thank you. Your Honor, this time we offer State's Exhibit 6.
Okay.
And the defense.
I have permission to take this on this number.
Sure. Do you want me to excuse the jury? No?
Officer, you're the client on the warrant, you said,
That is correct. Yes, ma'am.
you signed the affidavit that was used to obtain the warrant,
Yes, ma'am, I did.
and that affidavit is required to be sworn.
Yes, ma'am, I did.
Who administered the oath to you in that case?
Well, as the administration, I've put both in the affidavit as well as the submission when it does get transmitted to the judge, that the information contained therein is true and factual to the best of my knowledge under penalty of law.
So you swore yourself to this affidavit?
By submitting that search warrant, I did swear to that, yes, ma'am.
Did you record that, that you administered to yourself?
The oath is not verbally administered. In the transmission and submission of that search warrant, I swear that all the information contained therein is true and factual.
Do you have your body cam on? Well, I guess, is this something that you do regularly?
Yes, it is.
And you sign the affidavit,
I do sign a fair amount of search warrants, yes, ma'am.
and you typically swear to them yourself?
If I am the submitting officer, then Again, by submitting them, I do swear to their validity.
And so when you submit this to the judge, they're relying on just your words alone.
Yes, as I am the drafter of the affidavit.
And officer, what is your badge number?
My badge number is 5640.
Okay, because at this time, we're gonna object to the addition of the affidavit. Because the state has to establish that it was properly sworn. Additionally, Judge, this affidavit, it says that it was subscribed and sworn to on the 25th of July. It has a signature of VR that I assume is Officer George, but right below that, it says Peace Officer, and it gives the different badge numbers. It gives badge number 2015.
Yeah, Matt, Coach.
Sure.
Judge, yes.
Yes.
Is she referring to this page 13 of the record? Yeah, I would take cross-examining the signature of the bottom.
Are you saying something? I can't hear you. I'm gonna get closer.
Shows what the state saying that he needs to meet the first month and if I can the person is for himself. That's not a problem. Judge, can you take this since the defense manager and the director
Get closer, please.
You can go ahead and ask what cross the to ask about that. And because there is another signature, and so it may not be clear from what the defense is asking because he is the applicant on that circuit. So to make it clear, can we go ahead and take this witness since the defense had the chance to ask a question and took a long road out, we have our chance to ask. And you went and to that because he specifically stated he's for to himself, and I put it onto that when he taken it. So I don't think there's anything that he takes off the statement. He's for to his religion.
You never asked him if he signed.
Well, they asked him if he's supposed to, he said he's supposed to himself. So, well, here's that, and if he's supposed to it himself and somebody else signed it, then that would be.
Let's do that. Let me get the jury out a second. Hold on. Wait a second. Let me get the jury out because I don't want them here.
Hey, where's the deputy?
I'm going to excuse you for 2 minutes real quick so we can take care of housekeeping. Okay, please be seated. So I think that with the point that they're trying to make is they don't want you guys to be able to cure a mistake that there may be, right? So what you're saying essentially is that he's basically signing it and he's not swearing to it.
Well, right. And they could say, if they could take care of it, they could ask questions about the signature. Well, that signature is on the line that says subscribe as warrants for a new private state. And though somebody just signed, he's already testified that he swore to it himself, and that will be improper.
So as the state is saying, this is the applicant, and then it's saying subscribe and sworn to for on this date, and it says peace officer state. It says the badge number is equal. They did not ask, defense did not ask him what his badge number was. They did not ask what his.
She did. Yeah, his badge was 5460.
Yeah, 5046, I think.
Yeah, something.
and specifically asked him if he swore to it himself, and he stated yes, explicitly.
Right.
And he described how he swore to it by he put it in his words of these statements with them.
You know, I seem to remember like they changed the law some years ago where
Officers cannot scribe or cannot state themselves. There has to be another, in the presence of another, which is why there is another, which is why there is another signature, which is why I'm saying that there is a clarification. So this officer, this warrant in and of itself is still valid with whatever this officer is saying in his stand. So he's still the applicant, which is why he's saying it. What he's subscribed or what he's subscribed and sworn to is still valid because the words in and of itself say further applicant asks for an issuance of this order.
Here's the issue, Judge. That piece of paper just has somebody signing it. So I guess there's two different things going on. Whether or not that is his signature where it says sworn or subscribed to, that's separate from what he just said on the stand, which is that he swore to himself. So we don't know if he swore to himself and then just gave this to someone to sign. We don't know that. But what he just said was that he swore to himself and those words in the government, and that's not true.
And if that were the case, this warrant would not be proper, and then the magistrate will rely on this to issue a warrant to get his blood. If this is not proper, then his blood shouldn't come in.
Can I see it again? Yes, sir. Didn't say. What's your response, guys?
So the state is still saying that from what the testimony was, as far as this witness being the applicant and swearing or saying on the stand that he was swearing that this is what this was his work, that this was his product, or excuse me, that this is what he was subscribing and swearing to, does not change the validity of this document or that this was done correctly.
When you say you self-swear it, to me, that means you didn't go in front of, put your hand up, I swear that this is true and correct to the best of my knowledge. And, that's what it would mean to me.
That would be administering the oath which did not happen because he said he swore to himself.
So I guess the question is, can an officer self-swear?
I think we both just agreed that they can't. Right. That was just the state's position.
I mean, he testified, like, I heard it.
Take it off this, yeah. So, Judge, just because I'm a little confused, are they saying that the signature at the bottom, which doesn't say his name at the bottom, is his signature?
Well, I think that's even a separate issue.
Well, they're claiming that what he's saying on the stand does not validate what is being, is not validating what is being, what we're trying to get in. So they're saying because he said he self-swore that this is no longer a valid document. And that's not the case whatsoever, because again, clearly what is being shown on this piece of paper is that it was sworn correctly, that it was a completely different.
He said he self-swore.
Judge, that's not what's being shown here. All we see here is that we don't know what he did. He could have just given us this one and said, here.
How do you know that signature is not some other officer?
But it doesn't matter. We did ask him. He said he self-swore.
I said, who administered the oath? He said, I self-swore, which means he did not.
He described it.
Exactly.
With what
So
he put
then,
in here.
Down here, it says subscribe and sworn to before me. He had already told us that he
Self-swore, but even on even on the testimony, when they asked specifically, well, did you make the oath? He said no. So to me, that also means he did not self-swear, which is
Wait, say that again?
Exactly that.
Well, on testimony, when the witness stated that he did not actually make an oath, that then turns, in my opinion, means he did not self-swear, even though.
He didn't swear at all.
So, and that's what the argument is, because it's saying that he did not, there's a completely different signature. So because.
No, I think that adds credence to their argument.
It does,
Because,
There has
you
to
know,
be, well, there has to be another, there's an applicant and then there's another signature.
For who he's sworn
So
in
that
front of.
would, right, that there's somebody else that he has to swear in front of.
Which is the second signature.
Which is the second signature.
I think the testimony might be misconstrued that he can read the oath
That he
himself
can read the oath
and
himself
swear in front of
and
the
swear in
presence of
front of-
another officer who signed below his signature there.
Correct.
But that's not what he testified to, and I think the issue is that
To be fair, you only has to be self-swore, not if you only read the oath out loud in front of another officer.
It says subscribed and sworn to.
And that might not be his signature.
I'm saying, well, when did he swear? When did he swear?
So that's why I'm saying
testimony
that's
is clear.
That's why I'm saying that the questioning was not, that was my purpose. That's why I'm saying that does not go to what is being shown on the documentation. And as far as your questioning is, did you self-swear? And he's saying, no, I did not. And there's
He
some.
said he did self-swear. He said that explicitly. And I think if we need to have it read back, then maybe we do that. But I think that,
No, I heard it.
okay, it was
I heard it.
explicit. And I think that's the issue. And so there's no amount of questioning that's going to be, like, you're going to just get him to say it.
This B and this R that's on this line.
That might not be a B&R though. We don't know that. That's a
Well,
signature
that doesn't even
in
matter.
person.
That doesn't even matter.
That could be a whole different officer he read.
One at a time. This is consistent with other documents that he signed.
We don't know that.
It's a separate issue. I think we don't want to get lost in the weeds here, Judge. I think the issue is whether or not this officer went before another, took an oath. State's position is he did not take an oath. Our position is that and it sounds like it's your position too.
That's not our position.
Okay, let me not speak for you. We'll speak from our position.
Yes.
We heard him testify that he self-swore, and that's not
Judge, if I may.
sufficient.
So as far as the testimony about self-swearing goes, I don't know if that is necessarily meaning that he swore and subscribed to the oath by himself, administering it to himself. Or as we've seen on the video, there's another officer in the room and he's reading it out loud to himself, signing on on the line. And then another officer signs below him, sworn and subscribed in my presence on that second line there. A second officer, a second badge number, as is proper.
Subscribed and sworn before me means that this person took your oath and they signed. That's what happens with no.
But it's not his signature there.
Wait, but you're saying now that he swore in front of another officer.
I'm saying we don't know because the questions did not get to that. So the questions are only leading up to, did this officer swear?
I think, to be fair, if you took them on voir dire, I think that should at least give them an opportunity to ask a question or two, I agree with you about the self-swear thing. I think that that's what he testified to.
And I specifically asked, who administered the oath to you in this case? And then he went into his self-sworn, which means nobody administered the oath. I was required by case law.
And he's sitting here listening to our conversation at this point. So there's nothing I feel like that can remedy, like his testimony is his testimony.
And so if they ask him whose signature it is, he could easily say mine and then, or another
That's what
officer,
you
I'm
want.
sorry, he would say another officer's then what? There's no way.
Is that sufficient anyways? Shouldn't it be in front of a magistrate anyways?
Well,
Is it sufficient that an officer can swear to the other officer? Is that sufficient?
I don't know. I think you have to look into it, but I don't think it's like the officer. I just see in the presence of another, but I also don't know that just reading the statement out loud in front of somebody else qualifies as taking an oath either.
right.
So I just don't think this is sufficient.
I think, to be fair, I'm going to allow them to ask just a couple questions. I definitely see your position, but I'll give you a couple questions to ask him, just to be fair. But given in mind that, he testified that he self-swore. Okay.
That's
all right.
Thank you, Judge.
And then, so let him ask just a couple questions to try what you want. I don't know. And then I'll rule.
And this is outside the presence of the jury?
Yeah, right now.
Okay.
Right now. We're not going to do it in front of the jury.
So Officer Ward, you can see, there's a screen closer to you if that's easier.
Yes.
Now, we've discussed a bit about self-swearing. Can you explain what you meant earlier?
As far as the self-swearing, I believe I was being asked if I swore to my own, if I swore that my words in here were true and factual for the submission of that warrant. If I swore to my words right here, not as in like I administered the oath to myself.
Okay. Did you swear in front of someone?
So there is, when we submit these search warrants,
Objection, Judge, not responsive.
Please answer the question.
yes,
Okay. And that top line with the X, is that you signing the document?
yes,
And that bottom line, whose is that?
that would be the witness for the warrant.
That is not your signature?
No,
Okay.
Wait, I thought he said he did just sign it.
The above typed S /
got
Brian
it.
Ward,
Okay.
that's your signature, right?
yes, that is filled in by the leaders.
And the below S / and then a cursive looking signature, that is your signature or not your signature?
That is not mine.
And so who is the witness for the warrant?
The witness for the warrant, it would be also stated somewhere else as to who witnessed this warrant on that particular date. I don't recall.
But that wasn't you.
So these have to be signed by another officer before it will let us send them. So
And is that what happened in this case?
yes,
Is that a proper protocol?
as to my understanding, yes, it is.
After this, yeah.
What was your motion?
To exclude the blood, Judge.
Well, no, your motion was to exclude the affidavit. Okay, I'm going to grant that.
Yeah, you're so clear, there wouldn't be any testimony about the blood draw as well, right? Okay.
Judge, you would ask that we still have testimony about it, whether or not blood results are admitted. As part of the DWI investigation itself, he did take blood and lost blood to draw.
At that point.
Right, it's just going to confuse the jury though, you know?
If they say vote and say something, that's what it is.
We would ask that.
All right, so jury.
All right, please be seated. You may continue.
Thank you.
Yeah.
Now, Officer Ward, where we left off, I'm gonna get back to the defendant's demeanor at the station. Let's walk through that. So when he came into the station, what did you immediately notice?
I noticed that he was very irate as he walked into the station, very excited.
What do you mean?
Excited as in very agitated, upset, irate, verbally belligerent.
And in your, when you started with him at the station, where did you walk him from the moment that you first met?
That would be in the intoxication room.
Okay. Did he ever leave the intoxication room at some point?
Yes, at the conclusion of my investigation.
Okay. All right, yeah, published within previously, just to do 3.
Yes,
Okay.
yes, of course.
Officer, when you're talking through these SFSTs where you're trying to, how was he standing?
So he was standing, moving his arms, standing with his feet apart.
Okay, and in your other investigation to the DRE, what did that particularly indicate to you?
That would be just a lack of following instructions.
Okay, as far as a DWI investigation, is that a clue at all for you?
Yes, because there is just a, as as you have an intoxicant in your system, it obviously degrades your mental capacities and abilities to process information, and react accordingly to the information received from the external information.
And how would you describe his attitude at the station?
Very upset, irate, and uncooperative.
And because we've taken a little bit of break, when you're giving instructions for SFST, why does compliance with instructions matter?
To ensure that both my observations are due to intoxication-related stimulus, and to make sure that the both interview is conducted properly and the administration of the SFSTs is properly.
So would the inability to follow simple instructions be included in itself?
That would be a cue to me, yes.
A cue of what?
A cue of possible intoxication.
Now, you mentioned that his demeanor was a little aggressive. Did he answer any of your questions?
If I recall correctly, no, I don't think he did.
And when you're saying that he's standing there swaying, can you explain it to me?
Yes. So as you have the black line on the floor earlier, it extends up the wall to give a non-moving frame of reference. There was a noticeable sway in his stance that would be outside the just normal realm of a typical person.
And when you're investigating intoxicated persons, is it normal for those that you find intoxicated to be swaying?
Yes.
And the odor that you said that he had, can you describe it?
It was a very strong odor of alcoholic beverages.
And in your other 350 plus investigations, when you find someone intoxicated, is that also a clue that you typically observe?
That is a very strong indicator, yes.
So, officer, based on everything that you saw of the defendant and your experience as a DRE 350 investigations, what did every piece of evidence that you saw point to about the defendant?
That he was intoxicated and had lost the use of mental and physical faculties required to safely operate a motor vehicle.
Thank you. Pass the list.
Okay, please.
Okay, officer, been an officer for 5 years,
Yes, ma'am, that's correct.
and how long have you been on the DWI task force?
I have been assigned to this posting for about 3 years now.
When was your last DWI training?
My last DWI training, as can you be more specific, please?
So not every officer is a DWI officer, right?
There are a lot of officers who are SFST certified. However, their specific posting and their specific responsibility is not solely related to DWI. So
And so when officers have to call you to conduct an investigation because you have more specialized training than they do, basically.
yes,
You said that you're a certified DRE,
yes, ma'am.
and that's a drug recognition expert.
Yes,
Is it necessary for a DRE to handle a DWI?
no, it's not.
So a regular officer could do.
Yes,
Okay. Do DREs typically draft reports regarding their findings?
yes, they do.
Was a report drafted in this case,
Yes, it was
a DRE report?
a regular report from myself.
So you draft reports in every case, right?
Every case I am involved in, I do make a written statement.
How many reports do you draft?
Several
Well, per case.
per case, 1 to 2.
Okay, so how many did you draft in this case?
I drafted 1.
All right, why did you draft the second?
because a DRE evaluation was not performed.
Okay. And on your rec, you said that you smelled a strong odor of alcohol.
Of alcoholic beverages, yes, ma'am.
And you wrote a report in this case as you would every case, right?
Yes,
And you would agree with me that report writing is an integral part of the investigation process, right?
it's an accurate or integral part of the after action reporting, yes.
It's so important that you get some training on report writing in the academy or in your training, right?
We do have a report writing class, that's correct.
And they teach you to be as accurate and detailed as possible, right?
They do teach us to accurately report our observations, yes.
And is that because you will rely on your report later?
Yes,
Do your supervisors rely on your reports?
yes, they do.
Does the district attorneys rely on your report?
My knowledge, yes.
And you also rely on your report when you have to testify to facts, in cases where you might testify maybe a year later, right?
That is correct as well.
And so the report that was written in this case, was it written the same day as the alleged offense?
Yes,
And it was closer in time to the offense, right?
would have been after the investigation had concluded.
There's permission to approach the witness.
Yes, ma'am.
So there should be a copy of my report from that night.
Can you read your report? Don't read it out loud, but you read it yourself and tell me where you noted that there was a strong odor of alcohol.
Yeah.
You can find that portion.
It's right here. Do you want me to read it?
Sure.
Do you want me to read it also?
This is related to the odor.
It's, like I said, a slight odor of alcoholic beverages emanating from his breath in person.
I'm sorry, what kind of odor?
An odor of alcoholic beverages emanating from his breath in person.
What did you can read exactly what it
It
says.
said a slight odor of alcoholic beverages emanating from his breath in person.
Okay, thank you. And you would agree with me that slight and strong is not the same thing?
In the terms of the use of the words, no.
I'm sorry, objection or response, yes or no? Is slight and strong the same thing?
Those are different words, man.
Well, you first testified that you smelled a strong odor of alcohol. And then you read your report and said that you smelled a slight odor of alcohol. So did you smell a strong odor or did you smell a slight odor?
There was an odor of alcoholic beverages emanating from his breath in person.
I understand that, but the question is, was there a slight or strong odor?
I can only testify to what I had written in my report.
If you don't
So that would be a slight, man.
understood. All right, you did not conduct a traffic stop on Mr. Gonzalez.
No,
Did you?
ma'am. No, ma'am, I did not.
Did you personally observe his driving?
No, ma'am, I did not.
So your knowledge of the driving infractions is based on what you were told.
That is correct information relayed to me by the officer.
Well, you said that's correct information. Did you see him driving?
No, ma'am, I did not,
So how do you know it's correct?
because I find Officer Escobar to be a credible and reliable police officer.
When you first encountered, Mr. Gonzalez, he was already at the jail, right?
That is correct.
And you observed red bloodshot eyes
Correct.
and a slight odor of alcohol.
Correct.
Earlier you told the state that he had slurred speech.
Yes.
Well, you didn't put it in your report. Is there a reason that you didn't put it in your report?
So that I would not recall.
Did you have any issues understanding Mr. Gonzalez?
No, I didn't.
Did he have any issues understanding you?
Not to my knowledge.
You mentioned that, Mr. Gonzalez was irate when he was brought in. Right?
Yes, I did.
Have you ever met someone that was happy about being arrested?
Honestly, I can say yes, I have.
Is that common?
It is not common, no ma'am.
You also mentioned, that you asked him to stand in a specific interview position.
That's correct, yes.
And, this is the position that you typically ask everybody to stand in when you're about to conduct an investigation?
Yes,
Okay. So you asked him to stand on the line and put his feet together, right?
that's correct, to stand up straight with his feet together and his arms down to his sides.
And you wanted him to stand in this position while you conducted the interview, or were you preparing to start as a deputy?
At that time, I was going to conduct an interview.
And then you mentioned that he was uncooperative. So did he participate in that interview?
No, he did not.
Is he required to participate in that interview?
It's his right, he is not.
He asked you for a lawyer, right?
Yes, he did.
How many times did he ask you?
He made the statement of speak to my lawyer
Okay. And how many times did he reference a lawyer?
whenever I would ask a question.
And that's also his right, right?
It's also his right, yes, ma'am.
And so, and usually when people ask for lawyers, do you continue your investigations? Or do you give them, or give them the chance to get on it?
If, in these cases, if they request a lawyer or refuse to answer questions, that is absolutely their right to do so. However, there is a time constraint on DWI investigations, so we continue with the investigation.
You said that he did not participate in any of the field sobriety tests. Is he required to participate in those tests?
No, it is also his right to refuse.
And so typically, when a person is intoxicated or their mental faculties are affected, they usually remember what their rights are.
As they would have been told very closely too.
And you said that you read his Miranda rights, right? Or you told him what his rights were.
Objection to this testimony. I don't think the witness ever made that statement.
So did you read his Miranda rights?
On that particular night, I'd be able to refresh my memory on the report.
Are you saying you don't know?
I'm asking if I can refresh my memory of my report.
If you don't recall,
I'm asking, may I refresh my memory of my report, ma'am?
yes, you may. So I'll re-ask the question. Do you recall whether you read his Miranda rights?
Yes, his rights were read to him.
The part of Miranda tells us that we have a right to remain silent, right?
That is correct.
Which means that we don't have to participate in an investigation.
That is also correct.
And so would you agree with me that it would be unfair to say that a person was uncooperative just because they were asserting their right to remain silent?
I would not agree with that, no.
Okay. No further questions, Sherry.
Okay,
Ready for your right, Joe?
sure.
Officer, what else about the defendant made him seem uncooperative?
It's the fact that there was no type of cooperation with an active investigation, albeit that it was his right to take the opportunity during that particular investigation to prove an allegation was not found.
Now, defense had started talking about a slurred speech. Did you review your body cam for testimony?
Now, as that particular part, the camera footage in there was not actually conducted, or excuse me, hooked up to a microphone at the time.
So did you review your offense report?
Yes.
And did you watch your own body cam before coming here today?
Yes, I did.
in defense asked if slurred speech means that you can't understand people. Is that your understanding of slurred speech?
That does not mean, slurred speech does not mean you can't understand someone. No.
Okay. So what does slurred speech mean for a DWI investigation?
Slurred speech would indicate a loss of physical faculties and motor functions.
Okay. And when they don't participate, then being investigations, when a suspect doesn't participate in an interview, is that concerning to you?
Yes, it is.
Why?
Because the interview is used to ascertain if an investigation needs to proceed or if it even needs to take place at all.
And defense went down a line of questioning about you not being on scene that night. What was your job that night again?
I was assigned to the DWI task force.
Where at?
In the entirety of the city of Pasadena.
Okay. And where were you actually in Pasadena? What physical location?
I was at the Pasadena Police Station, 1201 Davis Street, in specifically the intoxication room, working on another DWI.
Is it common for DWIs to be brought to you in that room for investigation?
Yes, it is.
How common? Every time or most times?
A significant portion of the time.
Okay. So in your opinion, did you do your job?
Yes, I did.
Now, out of your 350 DRE investigations that you said, how often are SFSDs refused?
More often.
Sustained.
Based on your training and experience, is refusal a sign of intoxications?
It can be.
Now, hypothetically, if a person who is belligerent does not control their vehicle and fails to maintain a single lane and smells like alcohol, has red eyes, slurred speech, and refuses to do any tests to confirm or deny whether they were driving while intoxicated and only says that they want a lawyer when asked basic questions, would you say that person is intoxicated?
I would believe that is a degradation of mental capacity. And I would highly believe that that person would be intoxicated.
And on this incident that night, was there any doubt in your mind about the defendant being intoxicated?
So when I proceeded with my investigation, no, there was not.
No further questions, Sheriff.
Okay, anything further?
Very good, Judge. You said that participating in interviews helps determine if anything needs to take place at all.
If an investigation needs to be performed, yes, ma'am.
You would agree with me that the fact that he was told that he was being arrested for failure to maintain a single lane, transported to room 2 and having his car towed, quite a bit had taken place at that point.
That had taken place at that point, yes.
No further questions, then.
Okay. All right. This witness may be excused.
Yes, Judge.
State. Okay, thank you for your testimony. You may be excused. Do you have any further witnesses?
No, Judge, at this time, the state rests.
Okay,
And at this time, the ones will move.
let's
Okay.
shift them up. Do you mind taking our presentation?
Right, for the jury.
Okay,
Next we go for directed verdict.
on what grounds?
We don't believe that the state proved intoxication beyond a reasonable doubt. They didn't investigate. Their only signs of intoxication are this strong, slight odor of alcohol and the red glassy eyes that nobody investigated or asked questions about. They didn't get the requisite medical information to see if that was from something else. And this driving that is arguably not an infraction according to Officer Escobar.
Judge, we believe we presented more than enough evidence based on the testimony.
I think so too. Yeah, I'm going to deny it. I think that there's, yeah. So why don't we get the charge ready? And I'm going to give it to you guys to see whether you guys have any objections to it, and then we'll do closings real quick. All right, please be seated. Okay. Thank you for coming back. We will now begin with closing arguments. Or let me read the sign. I'm sorry.
I don't believe we rested.
Oh, I'm sorry.
It's okay, definitely rest.
Sorry. Okay, I'm going to read the jury instruction and then we'll get to closing arguments. All right. Members of the jury, the defendant Alejandro Gonzalez stands charged by information with the offense of driving while intoxicated in Harris County, Texas on or about July 25th, 2025. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take with you, to take and use during your deliberations. First, I will give you some general principles of law that you must follow when deciding this case. Then I will instruct you on the rules that control your deliberations. Finally, I will tell you about the specific law that applies to this case. The information. The information is not evidence of guilt. It is the name of a document required to bring the case before you. The information cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his or her innocence or produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt. After careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. It is not required that the state proves the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Evidence consists of testimony of the witnesses and materials admitted into evidence. Nothing the judge, has said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you're permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. You must follow these rules to request that testimony be read back to you. It must be in a writing signed by the foreperson. 1 states that it is requesting the testimony be read back. 2 states that there is a disagreement about a specific statement of a witness or a particular point in dispute. And 3 identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The law requires that you render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant's guilt beyond a reasonable doubt. You may return a verdict only if all 6 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his or her own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had testified or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the lawyers, you will go to the jury room. Your first task will be to pick your foreperson. The foreperson will preside over your deliberations and conduct them in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, you must stop your discussions about the case until all of you are present again. You must communicate with me, the judge, only in writing, signed by the foreperson and given to me through the officer assigned to you. You must not conduct any independent investigations, research, or experiments. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have the foreperson sign his or her name to the particular form that conforms to your verdict. You are instructed that a person commits the offense of driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. In this regard, public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device exclusively on stationary rails or tracks. Intoxicated means not having the normal use of one's mental or physical faculties by reason of the introduction of alcohol into the body. You have heard evidence obtained as a result of a traffic stop and detention of Officer Alejandro Gonzalez by Officer Escobar. Specifically, you have heard testimony of Officer Escobar and other state's witnesses suggest that Alejandro Gonzalez might have been operating a motor vehicle while intoxicated. You may consider this evidence only if you resolve a preliminary question in favor of the state. No evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America shall be used against the accused on any trial of any criminal case. The state must therefore prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. A police officer may, under the law, stop and detain a motorist without a warrant when the officer has reasonable suspicion that the motorist has committed a criminal offense, including a traffic offense. You are instructed that an operator on a roadway divided into two or more clearly marked lanes for traffic, A, shall drive as nearly as practical entirely within a single lane and may not move from the lane unless the movement can be made safely. An operator that violates this provision commits a traffic offense. In this regard, operator means, as used in reference to a vehicle, a person who drives or has physical control of a vehicle. Vehicle means a device that can be used to transport or draw persons or property on a highway. Police officer means an officer authorized to direct traffic or arrest persons who violate traffic regulations. Before you may consider the evidence obtained as a result of Officer Escobar's stop and detention of Mr. Gonzalez, you must all agree that the state has proven beyond a reasonable doubt that Officer Escobar reasonably believed that Alejandro Gonzalez was failing to maintain a single lane before Officer Escobar stopped him. If you find that beyond a reasonable doubt, then you may consider all of the evidence obtained as a result of Officer Escobar's stop and detention of the defendant. If you do not find that fact beyond a reasonable doubt, then you will disregard all the evidence obtained as a result of Officer Escobar's stop and detention of the defendant, and you will find Alejandro Gonzalez not guilty. Now, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Alejandro Gonzalez on or about July 25th, 2025 in Harris County, Texas did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of driving while intoxicated. If you do not so believe or have a reasonable doubt thereof, you will find the defendant not guilty. I now will sign the jury instruction form, and closing arguments will now commence. State?
Yes, Judge. Sure, the technology's working.
Did you want to split? Or you want doing everything?
We're going to split open and then save time for rebuttal.
And how much time did you want now? Or did you want to do half and half?
No, just 2-3 minutes right now.
Okay, just, I guess, let me know.
Yes, Judge. I don't know why it's. Yeah, afternoon. When we started this trial, we told you to come down to one simple truth. It's something that we all teach our kids. It's a universal truth that we all know. Choices. And choices have consequences. Right? It's something that we know so much that we're raised in it. We teach our kids it now, be smart, think before you speak, think before you act, make smart choices. And after sitting through today, you now know the story and the facts of a man who made a dangerous choice. The choice to get behind the wheel, the choice to drink, choice to drive, choice that we now know led to a commission of crime. The defendant, not just someone who appeared on that road that night. not just put in that position. It takes choice after choice after choice to be there, to be on that dash cam that we all watched. And now has come the time for those choices to meet their consequences. You see, in this case, the defendant chose on July 25th, 2025, in Harris County, to operate a motor vehicle in a public place while intoxicated. And this goes back to the very beginning when I was talking with you up here in the jury selection phase. These are the same checklists. Nothing's changed, except that now every single one of them has a piece of evidence behind it for you to check it out. Every single point on this list has been hit. And I want to come back to intoxication in a moment, because like I said, the defense is going to get a chance to come up here and speak to you. But before they come up here, I anticipate they're going to ask you to not look at what you've seen, but look at what you haven't seen. Try and focus on what you haven't seen in the evidence. They might say it was a long night. His red eyes because he was tired. It was 2 a.m. Might be an odor of alcohol because someone spilled something on him. Any of that in evidence? Is there anything that supports that? You see, when I talk about my dog star in jury selection, circumstantial evidence, connecting the dots, there's nothing in the charge that the judge just read you that says you are to leave your common sense at the offered TSA checkpoint downstairs. They have to come to the first floor. It's that you have to use it right now to know the defendant hit every single one of these elements. So I'm going to get another chance to speak with you after they have their opportunity. And I appreciate your attention this far. When I come back, I'm going to ask you to continue to use that common sense and reach a just outcome. Thanks.
Okay, thank you. Are you going to do it? Do you want to split it? You got it? Okay.
Good afternoon again. My heart is in my visa. And I don't know. Maybe said I'm gonna do a really good job for Alejandro. But before we get started, I want to take a minute to look at the jury instruction. So in the jury instruction, the judge talks about the ability to disregard evidence if you feel like it was unlawfully obtained, which means you have the power to not consider something that you feel like wasn't obtained legally. I'm specifically referring to the stop. If you feel like the stop was not a good stop, you as a jury have the opportunity to disregard everything that happens after the officer stopped Alejandro. Now, Officer Escobar, he got on the stand and he said that, oh, he was swerving all over the lanes and he was posing a threat to other people. But then when you look at the video, Alejandro may have been swerving slightly between his lane, right? But the law says that you are instructed that an operator on a roadway divided into 2 or more clearly marked lanes for traffic shall drive as nearly as practical entirely within a single lane. It doesn't say that you can't move back and forth in your own lane. Also talk about you may be able to move if it can be done safely. Officer Escobar said that, well, the court wants you to also show that they were posing a threat to other people. Nobody honked at Alejandro, nobody hit the brake, nobody tried to swerve to avoid him. And at every time that the officer says that he went out of his lane, there was at least a full lane between him and another vehicle. At no point in that video do you see Alejandro's truck straddle the line. At no point was he ever in 2 separate lanes. Now, Officer Escobar also told us that he likes to get behind Chevys and GMCs because they're commonly stolen. And then he mentioned that sometimes other motorists call in DWIs, but he likes to try to find his own PC. I'm not really sure what he meant by that because either you have probable cause to stop somebody or you don't. You don't go try to find it. He also said that he usually doesn't write tickets, and then he says that he sent cases to DWI to CYA or cover his ass. And I'm assuming that he don't usually write tickets because he takes people to jail to, I guess, CYA, right? To send them to the DWI unit, or because they're failing to maintain a single lane, but they're not posing a threat to anybody. Now we'll talk about Officer Ward. Officer Ward, very knowledgeable about standard field sobriety tests, but that knowledge does nothing for you because he didn't administer them here. So you know you can get to apply it here, right? Now, what I think this is a power struggle because you have both Officer Escobar and then you have Officer Rohrer, who both kept saying that Alejandro was belligerent. He was uncooperative. He didn't want to answer questions. Well, if I asked you for an attorney and I asserted my fifth, why on earth would I answer your question? And as an officer, why would you describe him as uncooperative because he's asserting his Fifth Amendment right? You read his Miranda rights to him. You tell him he had the right to remain silent, and then you get upset when he chooses to remain silent? That doesn't make any sense. The power struggle from Officer Escobar. You tell him, well, when you pull him over, he said, hey, what am I getting pulled over for? Why are you detaining me? Why are you asking me to get out of my car for failing to maintain single lane? And then Officer Escobar says, Pennsylvania v. Mills, we don't play court in the street. Okay, so it's okay for you to play court in the street and gives me case law that he probably don't even know what that means, right? But the minute I question it and say, well, why are you doing this? It's a problem and I'm being belligerent or I'm being uncooperative. So it seems to me that the fact that he chose to assert his right and ask a question, why are you pulling me out? Why are you searching me? Do you have PC? You now want to take him to room 2 to be investigated for DWI for failing to maintain a single lane when he never actually departed from his lane or posed a threat to any other vehicle? That does not make sense. And if the piece does not fit, then like Attorney Sykes said, or her slide said, you must acquit. Now, they also talked about him losing, and I guess their case is based on him losing his mental or physical faculties. While he was driving, when the officer got behind him, he drove for a minute, but when he got ready to pull over, he turned on his signal light, he got into the left lane, he slightly yielded at a blinking yellow light, then he turns into the parking lot without an issue, he stopped, he puts the car in brake, and when the officer opens the door, he has his seatbelt on. Seems like he was mentally capable to me. He says, officer, why are you pulling me out of the car? Why do I need to get out? What are you stopping me for? Seems mentally capable for me. The officer was actually pulling on his arm to get him out of the vehicle. He didn't stumble out. He didn't fall out. He got out of the vehicle. He stood there. When the officer cuffed him and walked him to the car, he was able to physically do all those things on his own, right? And then he got in the car, and I can admit, he started acting like an asshole, right? He was talking noise to the officer the entire time. But again, you pulled me over. I don't know why you pulled me over. You pulled me out of my car. I don't know why you pulled me out of my car. Now you're searching my car. You didn't find anything. And now you're taking me to room 2 to do an investigation. And mind you, at this point, he has not even mentioned a DWI. So Alejandro don't even know why he's being transported other than for failing to maintain a single lane. That does not make sense. So of course, he's upset. And then when he gets to the station and Officer Ward starts doing his questioning and saying, well, he didn't stand on the line. I don't know about y'all, and you have the opportunity to ask to see the video, but at every point on the video, he stayed on the black line. Now, maybe he didn't keep his feet together and his arms by his side, but officer, I already tell you, I'm not doing these tests, I want a lawyer. So when you go to the back and you look at all the evidence that has been presented to you, I want you to think about everything from beginning to end. Was he really failing to maintain a single lane? If he was not, and you find that the officer just pulled him over because he liked to send stuff to DWI to CYA, or because Chevys are commonly stolen, or because he wants to find PC, you stop right there and it's a not guilty. If you decide, okay, well, yeah, he kind of was maybe moving out of his lane a little bit, and you get to the point where you say, okay, well, maybe they can go do a DWI investigation, you got to look at the investigation, and you also got to consider everything that was brought before you. Now, Officer Ward got on his head and he said about 3 or 4 times, I smelled a strong odor. Oh, it was a very strong odor, a strong odor. And then when I bring him his report, he reads it and he reads just low enough that you don't hear him. And then I say, wait, read that part again. He completely disregards what type of odor it was and said, I smelled an odor of alcohol. So then I had to ask him a 3rd time, officer, read exactly what your report states. I smelled a slight odor. Is slight and strong the same thing? I mean, you want y'all to convict based on that? I don't think I need to say anything else because I know y'all gonna come back with not new me.
Thank you. Right?
Yes, Judge.
Please.
So I'd like to pick up almost right where she left off there. The jury instruction for you is to look at Officer Escobar's side. It's absolutely right. You're to follow the law. And you see, like she just said, and I wrote it down because I liked it. You see him moving out of his lane a little bit. Then you go to the TWI investigation. That's exactly right. Moving out of his lane a little bit is what happened. And when he's looking for his own PC, it's not what happened here about calling in and finding PC based on a call. And for that, him referring to that, meaning he finds his own PC to do an investigation before pulling someone over, not pulling over just based on the call. He's checking it himself. So that's a little misinterpreted there. But in this case, it doesn't even matter because he sees the whole thing. He sees him moving out of his lane a little bit. And that's enough for failing to maintain a single lane at 2 in the morning. In a lifted, tinted Chevy pickup truck here in Harris County. Now, let's go back to what I have to prove here. Remember this video from Port Ire? No, my planet. Where the ball comes out and we thought, what might run behind it? Oh, a kid? Well, I want you to look at the video from this footage. Where it looks like as he goes through his life, that white line under his right tire, he's out of his lane a little bit, staying there, coming back over to the yellow line, out of his lane. And when the lights come on, how long does he take to pull over? I don't know about you or me, but if someone pulls over immediately, that seems typical. If someone drives for almost a mile and doesn't get in a right lane to pull over, but instead puts a blinker on, goes through a yellow, then red light to turn left and pass up more parking lots. Officer Escobar said that there's concern for looting on a lifted truck with dark tinted windows, and that in other investigations, he's allowed to and has done in the past, pull someone out of the car for officer safety concern. But the fact of the matter is, he moved out of his lane a little bit. And by their own standard, we're on to the DWI investigation now. So now we're looking at the facts of what we saw on scene with the car, with him behind the wheel, and we're looking at what we see at the station. Back in Port Ire, in jury selection, we talked about these definitions and the faculties, right? How the law allows us, the state, to prove our burden of intoxication by the loss of normal use of mental or physical faculties due to the introduction of drug alcohol, right? That long sentence. What do we have here? Well, we heard from 2 people today, Officer Escobar, that he observed the defendant swerving, and we just watched that. That he observed the defendant pass several safe points to pull over, which gave him a concern for what the defendant might be doing in the car. He had red watery eyes when he met him. There was an odor of alcohol. And then we hear from Officer Rourke, the DRE, drug recognition expert, that he observed the defendant swaying while he's standing at the station. It's not like there's cars passing by him. It's concerning. It's not like anyone's in the middle of traffic making him step aside or something like that. He's in a room. It's a quiet room, and he can't stay still. That, as Officer Rohr explained, is a sign of intoxication. We also saw red watery eyes, an odor of alcoholic beverage, can't follow instructions, can't stand still, can't stand on the line, can't pull his hands by his sides, and we now know that that's important for SFSTs. That's important for determining intoxication because they're attention diversion. It's to see if you can listen to instructions and pay attention just like you have to behind the wheel. That's why if they find that SFSTs are okay, they let you on your way. Fact of the matter is the defendant never gave me a chance to conduct a full test of SFSTs, did he? Instead, he sat there repeating questions that were asked just minutes before, and he declined to do the test, and he declined to print the test. So what do we know about the defendant? We know that he has red watery eyes and slurred speech, he's swaying. And for these signs of intoxication in general, right, in general, what we know from Officer Escobar and Officer Rohr, that these are the signs that indicate to them that someone has lost the normal use of their faculties for the operation of a motor vehicle. Whether or not they're belligerently drunk is not what the standard is. These signs indicate to officers every day that they have lost their faculties to drive. And what do we see in the defendant? At the station, the same signs, red watery eyes, slurred speech, swaying, can't follow instructions, smell of alcohol. So what we see from Officer Rohr, again, the drug recognition expert with over 350 DWI cases and nearly thousands of SFSTs administered, he reached one final conclusion, that there was no doubt in his mind, based on his years of experience and training, that the defendant fit this box. And if sometimes you don't want to take the officer's word for it, sometimes the defendant can tell you themselves.
Against me tonight. Yeah, put in. Take me in. Fucking do. Fucking do.
Give me a PI. We learned what that meant. Give me a public intoxication. I don't care. Quote him, I don't give a fuck. Give me a PI. Give me a public intoxication charge. If you don't want to take it from the officers at the station minutes or hours later, take it from the defendant minutes after he's pulled from behind the wheel, that he's intoxicated. And so we go back to our checklist. And at this point, we know that every single element is hit. We know that honor about in Harris County, defendant Alejandro Gonzalez did operate a motor vehicle in a post-mix while intoxicated. And again, I won't play it again, but the defendant's own words give you more than enough to show you that at the time of him driving, he was intoxicated. And that's why at this point, we've come to what's known as the proverbial passing of the baton, right? This is the end of the relay race, the last lap. And it's my job to make sure that you are well equipped for your job, to go back there and ask each other questions and reach a just outcome. And at this point, we feel as a state that we have done that beyond a reasonable doubt. So when you go back to that jury room and you deliberate, I want you to remember two things. All the evidence that you saw from the witnesses reached one conclusion. He was intoxicating the time. And second, you flip the defendant himself, saying, give me a public intoxication, because he's not even hiding himself. Take me in. I don't give. Give me a PI. Charge me with intoxication. He knew in the moment that his consequences were coming. That his actions, his choices, had finally met their mate. And at this point, the only option is to find the defendant guilty of driving while intoxicated. Thank you.
All right, thank you. Okay, I think it's time for you guys. Are you ready? Should we bring this up? Yeah, should you mind handing this to them? And then if you mind taking them back to the jury room so they can deliberate.
All right, for the jury.
Remember, officer.
All right, for the jury.
Ladies and gentlemen of the jury, you have reached a verdict. Is it unanimous?
Yes.
Okay, if you wouldn't mind handing the paper over to Debbie Knoll, You know, hand me the verdict, all right, guys? Okay, in cause number 257-5231, the state of Texas versus Alejandro Gonzalez, we, the jury, find the defendant guilty of driving while intoxicated. Would you like the jury polled? No? Okay, you may be seated. Okay, ladies and gentlemen of the jury, this will take us to the next phase of the trial. We'll now begin the punishment phase of the trial. There are several things that I have to talk with the lawyers real quick. So I'm going to excuse you for literally about 1 to 2 minutes, and then I'm going to bring you right back in, and then we'll continue. Okay? Okay, please, if you don't mind.
All right, for the jury.
Lawyers, do you mind coming up real quick?
Yes.
You still want to go? Okay, what?
It's a 15-month probation with standard conditions of TRAS, DWI education, repeat offender course. It would be 30 hours of community service. And then
It's a second offense, though. I think that on a second, though, there's a 30-day minimum jail sentence, though. That's the problem. Whether, I mean, when the jury finds the defendant guilty, my reading of the statute, if that's the case, if you agree, okay. But I think that there is still a 30-day minimum. My reading is 30. I mean, because I was just now looking at it.
Is it 35 for probation on effective?
30, this reading of the statute, because I was looking at it here. Except as provided by subsection B, an offense under the section 49.04 or a class A misdemeanor with a minimum fine with a minimum term of confinement of 30 days if it is shown at trial of the offense that the person has previously been convicted one time of an offense relating to the operation of motor vehicle while intoxicated, or aircraft or watercraft.
So it's 30 at trial, but 5 before trial is what this statute is.
I even reached out to my staff lawyer just to be on the safe side. What they said is it's a minimum term of confinement of 30 days if it's found at trial that he's found guilty on the second.
But just technically, he hasn't been guilty. He hasn't been found guilty of the second. It's just, he's been found guilty of the DWI.
Yeah, I mean, and we need to do that as well. So it needs to be stipulated, or we have to have put on evidence that there's a second, and that would be, a fingerprint examiner, if there's no stipulation to it.
Would you all be?
sorry.
Would you all be amenable to doing as a person?
I mean, if you want to abandon the enhancement,
Which is what I'm saying.
and then we'll go the minimum of 5.
Right, this is what I'm saying. Would y'all be agreeable to doing it on first, that he's still doing the 5 days and with the probation 15, he does 5 days as a condition, but we do it on the first.
Yeah, you have my blessing.
If that's
That's what you want to
we
do.
can do it that way. I mean, 'cause at the end of the day.
We'll just put it on the record that all the parties agreed to it, and then, yeah. Okay. Okay. Right, we'll have it stipulated on the record that everybody's in agreement.
We'll do it. They're fine first.
And
But
then-
we'll stipulate it on the record for you.
Okay, no problem.
Yeah.
And then
Yes.
I'm going to go excuse the jury then, I guess.
Would we have the opportunity to talk to them?
Yeah, of course. Yeah, but let's do everything here first. Let's get it done. Once it's done, at that point, talk to them for 5 minutes, and then you guys can have it.